বললাম AD9 কেন দেখাচ্ছে? আমার তো এখানে এখনো দেখাচ্ছে না, স্ক্রিন দেখাচ্ছে না।
জয়েন করে দিয়েছি তো।
একটু একবার দেখো তো।
দাঁড়াও। দেখি আনমিউট করে কথা বলছে।
It said what matter when Lordship is sitting in court number 42.
Yes.
Well, what matter regarding judgment of the Supreme Court that when you are considering the matter, if the his eligibility, his case should be considered, but determination, your Lord release the matter. Now determination. It appears for us. Your Lordship twice heard the matter, and your Lordship practically was in my favor considering that judgment. But Mr. Mahato raised objection that your Lordship has no jurisdiction. That's why your Lordship leave the matter.
Maths teacher.
My Lord?
Maths teacher.
Maths teacher, right, my Lord. Maths teacher, but
he was appointed at the age of 17 years. Now they say that.
My Lord, kindly make it forward orders.
Now it has fallen in my determination now.
Yes,
right now.
Yes. My Lord, kindly unemployed, you kindly rescue him. He's a David over telephone.
Now,
please notice, my Lord, it appears for us. My Lord, get full, my Lord.
I am permitted to mention regarding pension matter, Mill. Pension matter. Pension matter.
yes.
Hello, I am mentioning one madrasa matter.
Only thing is you give a notice to the other side and then mention, because
in this matter, my lord, I am yet to serve notice to the other side, but the difficulty is that this pertains to, my lord, teacher eligibility test 2017 and teacher eligibility test 2022, my lord. In both these state, my lord, wrong questions has been set up by the West Bengal Board of Primary Education, my lord. Several writ petitions have been filed before this Honorable High Court, and this Honorable High Court, by order dated, my lord, 23rd of April 2024, my lord, formatted a committee and directed the expert committee to file a report with regard to the disputed questions, my lord. Those orders have been challenged by the West Bengal Board of Primary Education before the appeal court, my lord. Appeal court modified the order, my lord, in August 2024, and appeal court directed that 5 sets of, my lord, expert committees will be constituted, and those committees will submitted their report before your lordship, my lord. My lord, thereafter what happened, my lord, till, my lord, August 2024 till today, my lord, the expert committee yet to file the report, my lord. My lord, in July 2025, my lord, they have preferred a modification application before the division bench, my lord, stating that with regard to some other questions, my lord, they are facing difficulty to solve, my lord, what should be the correct answer, my lord. So the division bench, by order dated 11th July 2025, my lord, modified and add some more subject experts to the committee, my lord. My lord, division bench directed to file the report within 3 weeks, my lord. My lord, more than 4 months have been passed, my lord. The expert committee is yet to file their report, and more than 200 writ petitions is pending, my lord, pertaining to this subject, my lord. If your lordship kindly takes up the matter, my lord, more than, my lord, our anguish is that, my lord, by this time the West Bengal Board of Primary Education has come up with a recruitment notification, my lord, resulted, my lord, since we are unable to qualify the TET with
did the matter appear last?
My lord, last appeared, my lord, before his lordship, my lord, Justice Bharadwaj, my lord, but it could not be taken up. Then we mentioned before the division bench, my lord. Division bench, my lord, directed us to move before your lordship.
Okay. You have given a notice to the state?
Well, I shall file in
give
course
a
of
notice and then mention.
Well, may I come back tomorrow? Then, my lord, may I come back tomorrow?
Notice to the other side.
Yes.
Matter. You lost determination.
Yes.
My lord, may I mention the matter? This matter, my lord, this matter is already.
Please, if any matter is mentioned for listing under the heading motion, kindly mention in the top of the mentioning slip of motion. If the affidavits have been exchanged by and between the parties, it will be posted under the heading hearing.
My lord, may I, my lord, try to mention this matter, my lord? My lord.
What is the determination? Group? Where is the notice? No, give a notice. Mention. No. Give a notice. Sir, notice of mentioning the Calcutta. Yes.
I am
I to mention this matter is already appearing, my lord, in the.
Give a notice of mentioning to Mr.
Lord,
Sandal and mention
my
tomorrow.
lord, this matter was already appearing in the list of the Justice Malad Surugata Bhattacharya, my lord, as item number 1752. Well, let it be appearing in the list, my lord. It's already appearing in the list, my lord.
My lord, restoration to mention for inclusion, motion inclusion.
Yes.
My lord, new motion, lordship.
Motion to no motion.
New motion.
Primary motion includes
New motion. New motion.
Wait. You will take your chance.
My lord, only one request, my lord. There are certain matters where the senior citizens and pension matters are involved.
Motion.
Later on, my lord, we'll mention after listing, my lord, your lordship can because they are covered by your single bench judge. My
Motion is equal to
My lord, for
New
inclusion.
My lord,
You motion.
I am mentioning one madrasa matter, but this matter was heard by my lord Justice Bharadwaj before vacation, and his lordship was pleased to give a direction upon the madrasa board to pass an order for approval of the managing committee. No, lord, the order was not as yet, my lord, given to me. The matter was fixed after vacation. After vacation, the matter was not listed.
It will come under which heading? Motion.
my lord, restoration application, my lord.
But let this matter be listed at the top, because without approval, the managing committee is running.
Come up first. Let it be listed.
My lord.
Let it be listed.
Lordship, may I be permitted to mention one matter, Lordship? Lordship, my matter is transfer relating to a primary teacher, Lordship. Lordship, my urgency, Lordship, the motion at the admission stage. Lordship, the urgency is that the petitioner is suffering from maternity issue. Lordship, the doctor concerned has advised her that he has to undergo an IVF process to get his motherhood. The IVF process essentially requires a complete rest and all these things. The petitioner currently posted in a particular school where he has to travel 400 kilometers every day. So that's why the
Item
transfer
number.
is. I have mentioned that the details in the chat books as well as in the all details in my
Where is-
junior is there.
Who is here for the carrying the mentioning slip?
Yes, the mention slip has already handed over, perhaps. So I have given the
No,
details
what
in
is
my
that?
chat box. In my chat box also, I have given all this information in the chat box.
Ask your junior to remain present with the mentioning slip.
Because if the mention slip has already been handed over.
Transfer matters, my lord. SSK.
No, you are.
No.
No.
Nobody is here, Mr. Saha. Ask somebody to.
Polomi Chakraborty is there, some.
No, nobody is here.
Lordship, I'm handing over. Lordship, I'm handing over to your officers today, Lordship. He is perhaps there, Lordship. I'm handing over, Lordship. And that also, Lordship, I have given the details in my chat box also.
Chat box will not work. Give
Chat box.
junior to hand over the.
Yes, absolutely. Lordship, can it be fixed on, Lordship, any date, Lordship, because it is an awfully urgent matter, Lordship. Otherwise, I would not travel your Lordship.
May I hand over new motion?
Lordship, 10th on the 10th, on 10th,
Hello.
it can be.
One is to another, my lord.
My lord, may I hand over inclusion motion and two hearing?
May I be permitted to mention matters for non-prosecution? Non-prosecution of the writ application.
May I be allowed
To be mentioned.
বলে দিয়েছেন hearing and heading and
Please submit the written instruction on the date. It will be taken up. Yes.
My lord, may I have your lordship's kind leave to mention, my learned friend is appearing for the petitioner, my lord, I am for the respondent. My lord, I am led by Mr. Sandal, my lord, the pursuant to the order of the division bench, my lord, the report of the, my lord, the respondent is all, my lord, ready. My lord, now, my lord, it is, my lord, now to the court, my lord, to, my lord, decide the, my lord, your lordship.
So what did I tell you?
This is regarding date 2022. Just now
And
I have mentioned.
2027.
What did I tell you?
Your lordship directed me to serve notice to the other side. My lord, he is present.
My lord, I am also mentioning, my lord,
No,
independently, my lord.
My lord, I'm mentioning, my lord, this is the main matter where the
Lord,
division
may
bench
I,
passed the order, my
may
lord.
I
Civil
see,
matter.
my lord, order of the division bench or, my lord, at the time of,
At the time of hearing.
my lord.
Same issue.
Great.
Yes, just assisting your lordship, my lord. The most of the matters in the primary are transfer matters. At least to 60% matters as transfer matters and fewer A category matters. So, my lord, if your lordship is just a suggestion to your lord, if your lordship keeps a heading for transfer, puts all these matters, and there are usual orders. On the last determination, what we used to do, we give the usual orders, the usual orders used to be passed. So it can expedite the whole process, my lord. If there is one transfer heading, we would give the numbers to your lordships. If it's subject to lordship's convenience, any day subject to your lordship's convenience, your lordship fixes, or one day in a week, then my lord, it can be disposed of. A bulk of matters can be disposed of. One, and my lord, other some A category matters that can be also that already been decided, these issues, your lordship can also keep those matters and can be disposed of with the similar orders. So this is a suggestion to your lordship, my lord.
আমাদের এখন নিশ্চয়ই শুধু 25 আছে আমাদের কি শুধু 25 আছে ফল আছে তো সমস্যা আছে তো আমাদের এরকম পঞ্চায়েতের মধ্যে কিছু করতে হবে পঞ্চায়েতের মধ্যে কি করতে হবে
একটা দিন
আরে চলে গেছিস
একটা দুটো দিন দেখলে হ্যাঁ
ঠিক আছে ঠিক
My lord, I beg to mention a matter, my lord.
কথা বলি না
ডাকুন একবার দেখি
My lord, a group 2, my lord.
Grateful to your lord.
I'm praying for inclusion. My lord, a group 2 motion, I'm praying for inclusion. The matter pertains to termination of the petitioner without following the due process of law, my lord.
নিয়ে নি
Right.
ডাক
one matter of your lordship's list, my lord, it was appearing in the list. My lord, thereafter went out, my lord, with the change of determination with regard to disciplinary proceeding. My lord, my service was dismissed with stigma. I preferred an appeal before the appeal committee set aside the order. Now, my lord, it is pending since then, since 2018, without any benefit given to me.
But what happened to the disciplinary proceedings that has been set aside?
That was set aside out of 12 charges. 6 charges were remanded to be decided within 3 months. I mean, a disciplinary authority, Howrah District Primary Council, they preferred a writ. That is pending. Affidavit exchange ready for hearing.
Okay,
This period I have challenged that order of remand, because that is otherwise infructuous. It expired 3 months in the year 2018 itself. That
who is on the other side for the state, give a notice and then come back tomorrow.
There you go. Then on Thursday, kindly give me liberty to mention.
On Thursday, you come with the service of notice?
Yes, that is.
For item number 1, Advocate Shobhata is appearing for the petition.
Well, I'm for the respondent.
Well, talk dictation though. Never goes for. May I ask you, Nami? Yes.
Lordship, the last occasion I filed my supplementary affidavit.
You are for the?
I'm for the petitioner, Lordship. Lordship,
Petitioner?
Lordship, with your permissions, I'm just submitting the brief fact of the case. Lordship, the petitioner was working in this Said school, that is Bagmora, South 24 Pargana schools from 2001 to 4 as a part-timer teachers. And after that, he appeared in 2016 upper primary SLST.
Is for WBCSC.
My lord, I am for the commission. West Bengal Central School Service Commission.
and he qualified with a 65% marks, Lordship. And after that,
Hey, yeah.
he's
Just a minute. এই পাখাটা বন্ধ করুন, ওই দিকের পাখা চালিয়ে দিন। এই তো পাখা বন্ধ করুন, ওদিকে পাখাগুলো চালিয়ে দিন। শুনতে পাচ্ছি। Yes.
Lordship, with 65% marks, he was
Take the
qualified.
microphone.
With 65% marks, he qualified his examination, and after that, he was called in the interview. Now, Lordship, on this juncture, he was not allowed to be the part of this verification test, and he, by the RTI, he came to know that he will be called for. And when he was called for, he was not taken into consideration by the concerned authority. Lordship, please kindly come to page number 14 of my supplementary affidavit. 14 of the supplementary affidavit. where
He
the
appeared in which exam?
Lordship,
He appeared in which exam?
2016 upper primary SLST, Lordship.
Wait,
2016.
Yes.
Now, Lordship, please come to page number 14 of my supplementary affidavit. The concerned authority, that is West Bengal Central School Service, passed and reasoned order. Just come to the page number 14 is the main, the order start from page number 14. Come to page number 14A, where they are stating that the para teachers quota is not taken into consideration now, as this matter is sub judice under the Honorable High Court, Calcutta, and so this appeal could not be considered at this moment. And by this order, he was pending from such a long period, and he was in a hang position, Lordship. Lordship,
What is the order passed by this court? Whether to consider the
panel is not cancelled, Lordship. 2016 panel is not completely
they say that the para teachers quota is not taken into consideration as the matter is sub judice. Any order passed by this court? Any order passed by this court? Because they say that
Lordship,
they cannot consider it.
Honorable Justice Moushumi Bhattacharya passed that order that or section 12 clause 2 of this act need to be considered, and they give the direction to the commissioner that investigate properly and take the consideration of the persons who are appearing into. And after that, it is went to the division bench, Lordship.
What is the order passed?
The Lordship, right now I don't have that order, Lordship, because Mr. Advocate Shobhyaji Mukherjee, my senior, is appearing. So I'm just submitting the brief. And Lordship, if kindly make date to be fixed, that so he can submit, Lordship.
This order, reasoned order, has been passed
Yes, Lord.
pursuant to any order passed by this court? Where is the order of WPA 10789 of 2021?
Lordship. Lordship, for that reason, I'm just praying for short day to be fixed so that I can come with my order, Lordship.
এটা কি হিয়ারিং লিস্টে নিয়ে যান?
Grateful, Lord.
Tension matter, motion one and all the affidavits are complete. You filed your application.
No, my lord, this is my lord appearing in the under the heading pension matter, though it's not a pension matter. But my lord, this is in motion stage. Now, my lord, they were silent about this matter. My lord, now it has been listed and being moved. Now, my lord, the position is, my lord, in upper primary selection process, it is on the verge of completion. Regarding the my lord para teacher, what happened, my lord, pursuant to the order passed in that, my lord, WP number, the order your lordship is seeking for, my lord, the passed in WP number 107 of 89 of 2021, my lord, the commission was directed to, my lord, the giving the candidates, my lord, liberty to file their grievances before the commission, and commission was directed to, my lord, consider those grievances. Now, my lord, this is the copy of that order passed by the grievance officer. My lord, he filed a grievance, and my lord, that was duly considered, and this is the order.
because one of the para-teacher matters were under sub judice before this honorable court, my lord, the grievance officer rejected. Now, thereafter, my lord, what happened, that he has suppressed. My lord, the verification process was, my lord, conducted, and my lord, he was called on 15th February 2024. 15th February 2024, he was called in the, my lord, southern region of the commission. He was absent on that day. And he did not, my lord, participated in the verification process, and that's why, my lord, that his candidature could not be considered.
But then what about this order? Past person to order passed in the other writ petition?
My lord, your lordship is...
Where is that letter that he was called for verification? He did not appear?
No, my lord, it's page 14 your lordship is looking at. My lord, page 14, my lord, kindly see the date. My lord, 23rd September 2021. It is much prior to that, my lord. Thereafter, my lord, several proceedings, my lord, the decision was taken, para-teacher selection process was, my lord, taken afresh, and my lord, the verification process was, my lord, conducted. After the verification process, my lord, the merit list was prepared, interview list was prepared. Now, my lord, in the verification process, he was absent, and he did not, my lord, approach the commission thereafter.
Where is that letter?
My lord,
where is that letter that he was after 2021, he was called for verification on 2024?
My lord, that is not with me, but my lord, it was, my lord, circulated in the official website of the commission. It was published, duly published, and my lord, on the basis of that, my lord, all the candidates appeared and, my lord, participated in the verification process. But the petitioner was absent.
This copy has been given to you, supplementary affidavit?
My lord, supplementary affidavit has been filed by the, my lord, petitioner. They have suppressed, they have not, my lord, disclosed this fact.
This copy is with you? This has been served with you?
My lord, that
supplementary affidavit?
Yes, yes.
Will you be filing any opposition to the writ petition?
No, my lord, there was no direction.
No direction?
My lord, in my respectful submission, the matter has become infructuous because, my lord, the selection process has, my lord, proceeded with. My lord, at the material point of time, at the material stage, my lord, the petitioner was absent from in the verification process, and that's why, my lord, the proceeded further, and his candidature could not be considered. Now, at this stage, my lord, there is...
By the present writ petition, the petitioner seeks for appointment as a successful candidate on reserve quota for SLST 2016 for para teacher.
No, my lord, in the upper primary.
Upper primary.
Under the category of para.
Yes.
My lord, the selection process was, my lord, first SLST 2016 for the in the schools of, my lord, upper primary level, and, my lord, he applied under the category of para teacher. Right?
First SLST?
To the prayer portion of the writ petition?
Yes, my lord. Only there is...
This is what the petitioner states. For appointment of para teacher in general or reserve quota?
Wrong state.
Then?
Lordship, I appeared for upper primary.
No, come to page 15. Then the prayer is wrong.
Both for the appointment of para teacher in the general or reserve category, reserve quota under the school. Para teach for appointment of para teacher, there is no selection process conducted by the commission. The selection process was for the, my lord, upper primary level of schools. Teacher in the upper primary level.
In prayer A, prayer B, you seek for appointment of para teacher in general or reserve quota?
2016 para teacher SLST.
The entire petition is defective, my lord, and the suppression of fact is there, my lord. Material fact.
You will know? For SLST 16. For para teacher in the said school. In such school, in such prayer, in such school. learned advocate for the state, Mr. So-and-so, learned state,
I am for the commission.
WB CSSC, submits that the present writ petition has become infructuous since in the year 2024, despite service of notice, the petitioner failed to appear for verification. State is directed to furnish a report in the form of affidavit on the returnable date. Please this matter under the heading hearing. Hearing at the end, yeah?
Grateful, Lordship.
On কবে দেবো দেখুন, দেখে নিয়ে এগুলো পেচ আউট করে
মানে
2 weeks পরে একটা ডেট।
ডেট দিচ্ছি
12th বা 13th, 2 weeks 17th চলে যাচ্ছে না, after 2 weeks করে দিন।
কত হলো?
After 2 weeks, this will appear under the heading hearing. On such date, by such date, you file a report in the form of affidavit giving an advance copy.
Instead of 2 weeks, can it be 3x?
19 matters. 3 weeks.
3 weeks. 3 weeks. Grateful. Extremely great. তিন সপ্তাহ বাদে আসবে।
After 3 weeks. আচ্ছা, under the heading hearing.
কি বলুন তো? জানাই নি
কি হলো?
চেঞ্জ হয়ে যাচ্ছে।
ভালো হয় নাই।
জানাই নি না।
তাও বুঝতে পারছি না। শর্মা করে একটা মেনশন for the
Next.
Great.
May I permit to mention?
No.
Mr. Justice Sharma is not sitting today and tomorrow.
Justice Sharma is
His lordship's determination has been shifted to your lordship.
Just we have got the intimation just few minutes ago, Your Honor.
Actually,
Justice Sharma determination will be transferred to your court, Lordship.
Not transferred.
already
That is
been
time being for this day only.
Yes.
Yeah, we have
Today and tomorrow.
Today and tomorrow.
Today and tomorrow. Just intimation passed. Just this intimation passed few minutes ago, Your Honor, Lordship.
Actually, this is an extension of interim order. Interim order expiring tomorrow.
Okay.
That is why I mentioned.
Give to extension of interim order.
And another is for the 1544/2025, Your Honor. I am for the opposite party too, for the wife, ill-fed and ill-clad. On puja vacation, husband has driven away. Husband driven away the wife, Your Honor. That is the main cause. He has just quashed the petitioner wants to quash wrongly, actually pretending that he has given the notice to us, but he has given not.
With the regular court. What is the urgency? On 6th,
Urgency, he has ill-fed and ill-clad. He has driven away from his in-laws, from our in-laws, Your Honor.
Cause of action had arisen when? In these 2 days? In the last week?
Last week, no. That is
what is the urgency?
Urgency is
the matter is pending. Matter will be heard. They have filed their affidavits.
Absolutely, Your Honor. Lordship.
Let the regular court come. It will listed. If it is extended, then you mention.
Lordship. Extension of interim order.
Not now. 6th of November will see. I am on 3rd and 4th. No.
May I be permitted, my lord? My lord, the petition
It is item number 2.
My lord, no, not item number 2. My lord, this is
My lord, may I have my lord's kind leave to mention
number 42.
Yes.
But the urgency is that he is the erstwhile Vice Chancellor of Vishwabharati University. Several cases were lodged against him. This honorable court was pleased to quash most of the cases. But in this particular case, section 354B was included. After 3 years, the 161 statement was recorded, and after 3 years, the seizure was made. The next date is fixed on the 10th of November for framing of
Not
charges.
now.
This is the urgency.
Not now.
My lord, may I have my lord's kind leave to mention?
Which determination?
My lord, may I have my lord's kind leave to mention, my lord?
এটা আবার কি আছে? আর কি করে দিচ্ছে গো? This is the determination of which court? And you have written courtroom number 32. Everything will be wrong and I will list it. The courtroom number is wrong. So which matter, which court? No.
Well, with my lord's kind leave, my lord, may I mention a very urgent matter pertaining to list of Justice Sharma. My lord, I would seek a leave of your lordship to file it today and move it. The urgency is, lordship is well aware, the criminal code permits an executive magistrate only to direct the police to ensure law and order. He cannot delve into civil rights. He, my lord, passed an order, mandatory injunction ex parte, preventing us from entering into the scheduled properties which are school premises. Effect is this: we are very renowned school, my lord, AG Church, Asansol. We have other 3 schools, my lord, near Raniganj, Okra. My lord, the principal, board members, teaching and non-teaching staffs are prevented to enter.
You file in the regular course, let it be listed before the regular bench.
My lord, the problem is, my lord, the school cannot function. My lord, that is the, my lord, the problem, my lord. If
file in the regular course and
my lord, may I say this? The order passed on Wednesday, we received on Friday. Saturday, Sunday were holidays, my lord. Today, Monday, we have prepared the petition and come up to your lordship.
File it.
My lord, we shall file it. My lord, kindly, my lord, at least, my lord, direct the matter to be listed tomorrow.
No. Yes.
My lord, item number 2 of your lordship.
Number 2, this item number 2 writ petition is only limited to the interest on delayed payment of gratuity, my lord.
But the other part of the writ petition has already been complied with. There were other directions.
Yes.
My lord, the affidavit of direction for affidavit was passed. My lord, I am filing the affidavit today. The lordship may fix the date for hearing.
Affidavit only to the supplementary affidavit,
Yes.
my lord.
Not to the original writ petition.
No,
My lord. Only the
my lord,
limited
pension,
issue has
gratuity, everything she has received. Now the issue is involved is only regarding the interest component.
Interest on
Now, my lord,
delayed
whether your
payment,
lordship will enter into the calculation of the interest of the on the gratuity, whose liability delay it was on whose part, these are the issues to be decided by your lordship now.
This has been admitted.
Now, my lord, I have
that
filed the
affidavit
affidavit.
that the
I have
school
served
is
the
at
copy
fault.
on my learned friend.
This has
Lordship
been
will accept.
admitted in that affidavit that the school was at fault in paying the gratuity.
My lord, that was not the
This is
that was not the
only issue,
observation.
my lord.
That was not the observation, my lord. There are several directions, my lord. We will place before your lordship at the time of hearing. Lordship may kindly fix the date for hearing, my lord. Since the motion stage is already over, we have filed the affidavit also.
My lord, kindly take it up today, my lord.
Today.
Because the writ petitioner is aged person and this is only the interest on
First
delayed
of all, my
payment
lord,
of
a
gratuity, my
private
lord.
school, my lord, against whom writ petition doesn't lie at all in my sole submission. My lord, friend is for the state.
My lord, role of the state is very limited. My lord, by an order passed by this honorable court, DI was directed to take a hearing of the writ petition and school management. Already hearing took place, and my lord, accordingly, the report I have filed in terms of the order on 6th of January 2025, I filed a report disclosing that it's a business relating to the school and the writ petitioner. In my report, I have disclosed all facts. There was a mistake on the part of the school management for non-deducting the amount of the provident fund. 2,55,000. That was going to be realized from the petitioner's final payment. And this is the dispute.
And accordingly, my lord,
Well, that amount has been deducted and the remaining amount has been paid. That is admitted position. Now, my lord, only the delay on whose part? Number one, either on the petitioner or the school, and my lord, if at all, and my lord, whether the what will be the interest component. That calculation is to be done.
Okay.
So, my lord, in my report in last paragraph, I have requested on a district inspector school so that the petitioner get the provident fund with interest in accordance.
Provident fund has been paid. Provident fund is not the school's liability. Provident fund has been paid.
Permissible interest also.
They have claimed interest on the provident fund.
No,
No,
delayed
on the
payment.
gratuity.
Delayed payment of gratuity, my lord.
Okay.
3 lakhs and odd total gratuity amount.
But as I have taken the
after 4
point, my lord, in
years-
the affidavit, that the payment on gratuity, my lord, the interest calculation, all these things are subject matter to be decided before under the Payment of Gratuity Act, before the appropriate authority.
No, payment of gratuity.
Well, that is my
Act not-
submission, my lord.
is not
Subsequently, at the
applicable
time
to
of
the
hearing,
teachers, my lord. Payment of gratuity act is not applicable to the teachers,
Yes.
my lord.
fine. He's claiming gratuity on under what act, my lord, the land friend will submit at the time of hearing.
What is your case? Now place your case, we see.
Lordship, would hear it today, my lord, I'm just praying for a short accommodation, my lord, for the hearing.
Affidavit in opposition.
I have already served the copy.
May I file my
Filed by
reply,
respondent.
my lord? May I file my reply?
Respond number 4 and 5.
On the last 2 occasions, they have
The
paid for time,
supplement-
my lord. Kindly consider this also.
To the supplementary affidavit of the writ petition is taken on record. Affidavit in reply to the affidavit in opposition filed by respondent number 4 and 5, next paragraph, is also taken on record. Mr. Shubham, you are for 4 and 5.
4 and 5.
Mr. Shubhamoy Bhattacharya,
Lordship.
learned advocate appearing for respondent number 4 and 5, 6 accommodation on the prayer on the prayer of learned advocate for respondent number 4 and 5. Release this matter. And the hearing is begun. Weeks further to do.
Kindly fix any date, my lord, subject to your lordship's convenience.
Great for me.
My lord, matter will appear on, my lord.
Matter will appear on after 2 weeks. Which date?
Any date sub convenient.
17th.
17th.
17th November.
Grateful. Grateful.
My lord, the state advocate is in circuit bench Jalpaiguri. So if you will please to fix it day after tomorrow.
Earlier occasion, they have also took the time for filing the report. My lord, in this matter, what happens, the petitioner was retired earlier. And my lord, he is not getting pension only on the ground that he has not nominated anyone of his wife or anyone in his pensioner form. Thereafter, as per the direction of this court, my lord, the form has been submitted without giving any nomination. My lord, under the rules, pension rules, there is no guideline that if nomination has not been given, the pension cannot be given to a person. My lord, there is a procedure therein, rule, and my lord, Rule 19 of that procedure says on what occasion the pension can be withheld or cannot be given to a person. On that score, my lord, this point which has been taken by the state authority, that was not correct. So, my lord, this honorable court again directed them to allow his pension, and my lord, that was not given. Several order has been passed by this honorable court or the earlier bench regarding when this matter is going on. Deposition of Part A form, Part B form, everything has been given by the petitioner. Now it is their part they will send the same to the DI, or the SI will send the same to the DPPG, and there should be a direction upon the from the court that the DPPG will give him the pension and the gratuity and everything. PPO would be issued. On this occasion, my lord, this matter has been, for the purpose of report, this matter has been.
Your affidavit?
My lord, my affidavit
Yes.
regarding my lord, affidavit of
By the last order, leave was granted to file an affidavit, probably against the report.
No, my lord. That regarding this report, my lord, the learned court has heard the same, and thereafter, my lord, they want to file a report. On that occasion, we have produced two documents that we have already deposited our Part A and Part B form. That is there also form, my lord. Your lordship, kindly see the last report. That is probably on 19th September 2025 report. They have
Place for leave to file an affidavit. No, by order dated 22nd September.
Yes, my lord, I have gone through this order, my lord.
So what was the leave? Why did you pray for leave to file an
Lord, I don't know, my lord, because, my lord, I am not undertaking to file any affidavit regarding this report, because this has already, who is the form and everything I have already been deposited. My client has already been submitted. Your lordship, kindly see this report dated 19th September 2025. Then it will be clear to your lordship, I think, my lord. Your lordship got the same?
Yes.
May I read it for your lordship?
Yes.
Petitioner Samir Kumar Mondal was a retired teacher of Arsa Primary School under the Arsa 2 Circle, Purulia. Retired for service on 30th November 2023. He applied for pension through e-pension portal on 3rd September 2025 to the Sub Inspector of Schools, Arsa 2 Circle, Purulia, without nomination of DCRG, LTA, and family pension. He has partly filled in spouse information under personal detail in Part A, applicant part. Also, it is mentioned that he did not submit the following documents: enclosure A, 3 specimen signature of the pensioner duly attested by Group A, erstwhile gazetted officer. Enclosure B, 3 copies of photographs, single joint and attested on front side by Group A officer. List of family members, service related document. Concerned Sub Inspector of Schools forwarded the pension file to this office on 15/9/25. But the pension file has been returned to the concerned sub inspector with the observation and requested to comply the above order by concerned authority. Then the concerned sub inspector returned the pension file with the above order to the applicant, that is the petitioner such and such. As soon as the petitioner complied the above observation in his part and declared that he did not want to nominate anyone for DCRG, LT and family, then the pension file will be processed. Well, the already petitioner has already given undertaking that he will nominate anyone.
He will not.
Yes, he will not.
But then what about the enclosure A, B?
That has already been given, my lord. Earlier occasion, this was pointed out and this was already been given, my lord.
You have complied all this? You have complied?
Yes, my lord. Everything has been complied.
You have the copy of the receipt?
তোমার কাছে রিপোর্টটা আছে তোমায় পাঠাই আরে তুমি রিপোর্টটা পেশ তোমাকে তো বললাম যে তুমি মালাড রিপোর্ট ইজ উইথ দেম মিস্টার বিকাশ মুখার্জি ইজ বিকাশ গোস্বামী ইজ অ্যাপিয়ারিং হি ইজ অন জুনিয়র হি সিন্স হি ইজ নট দ্য স্টেট প্যানেল হি ক্যান
When he is coming?
আরে তুমি রিপোর্টটা দাও না জজ স্যার
I am not in panel, state panel.
কি আছে আরে তুমি তো রিপোর্টটা নিয়ে আসবে
Tomorrow?
Day after tomorrow, my lord. He will return.
Tomorrow is holiday. So coming week is in Monday.
Malad,
Yes,
then Malad, your lordship can fixed on Thursday. Because day after tomorrow holiday, day after Thursday.
Yes, my lord. Thursday.
Thursday.
Yes, my lord.
Mr. Swansol, learned advocate, seeks accommodation on behalf of Mr. Vikas Goswami, learned advocate for the state. In view of the above, is this matter on 6th November. Under the same heading. Need. 6th.
রিপোর্ট দিতে পারো তোমার নামটা দাও তোমার নামটা দাও আরে তোমাকে দিতে হবে তুমি তো প্রক্সি অ্যাডভোকেট নামটা দাও
I am for the state, my lord. My lord, in terms of the order of the Honorable High Court, I want to file the report. My lord, in terms of the order dated 17th September
For the petitioner led
2024,
by
Justice
Mr.
Amrita
Vamshivardhan
Sinha
Maitam, praying for
directed
not
to
to
me
remind her.
on behalf of the state, filing the report, my lord. My lord, several occasions the matter was appeared before the Honorable Justice Rajashri Bharadwaj, but petitioner advocate did not appear, my lord. So I want to file the report in favor of the state, my lord. Actually, my lord, petitioner has accepted 3 months excess salary, my lord. Now he is wanting refund the said amount, my lord. And kindly see
You have served the copy?
the report. I have already served, my lord.
None appears on behalf. You are for the petitioner.
And for the petitioner, I'm praying for not today, only not
My
today.
lord, several occasions of the matter adjourned.
A report in the
Intentionally, he is
affidavit
not
filed
appearing,
on
my
behalf of respondent number 4 is taken on record. কে দিয়েছে রে?
It is not a case of the pension.
এ দেখো তো এটা কি জমা করেছে? এটা এখন এড়ে দিল নাকি? হ্যাঁ?
I have already served, my lord.
Format?
তুমি তো know এই কিছু তাহলে why are you saying
See.
you are not
Hmm.
you are paying for adjournment?
A report in the form of affidavit filed by respondent number 4 is taken on record. Copy served. কি বলছে petitioner?
My lord.
What is your submission? What is your what is your submission?
এটা নিয়ে
Praying for food. 2 days accommodation, lordship. Today.
Monday তে রেখে on the prayer of learned advocate for the petitioner. List this matter on 10.
My lord, report filed on behalf of the state by the record.
10th.
My lord, the matter is adjourned till
10th Monday.
my lord.
My lord, I am for the petitioner, my lord. Pay agree with service. Lord, the matter relates to me, Lord. Retirement benefit by the widow of the deceased teacher. Widow of the deceased teacher, my lord. The teacher was the husband of the petitioner, was the primary school teacher, my lord. Retired, my lord, in 1995. And thereafter, my lord, she died in, my lord, 2015. My lord, he could not pay the, my lord, government share as per decision of Honorable Court, my lord. Now, his wife had made representation, and my lord, so many, my lord, decision of the Honorable Court, as per decision of the Honorable Court, my lord, division with judgment. The my lord, civil, my lord, bench has passed, my lord, judgment. My lord, I am submitting, my lord, the copy, the corrected copy. My lord, this is the, my lord, similar judgment, my lord, and on the basis of, my lord, judgment relying in judgment of the Supreme judgment of the division bench, which has been annexed to this petition also. This order has been passed.
They would have to calculate the amount required to be refunded.
CPF to
by the
GPF is
petitioner to get the benefit of the particular said amount.
This relates to, my lord, switching over from CPF to GPF.
My lord, Justice Mantha also, my lord, passed this order, my lord. Similar situation, my lord. Settled law, my lord. My lord, after, my lord, tested by the, my lord, on a division bench, as well as, my lord, I have annexed decision judgment, lord, page 63. The writ petition. Has been tested.
তারপরে রিজেকশনটা
There are page 67.
রিজেকশনটা তো তারপরে সেটা 23-এ তারপর এটা আবার 24 তারপর 24
58. আর হচ্ছে এটা 43.
Petitioner is the widow.
Yes, widow.
Yes.
My lord, kindly takes page 53 once. Page 53, my lord, kindly see, my lord, that in reference to the above, the undersigned is directed to inform you that the state government with a notification dated so and so introduced the opportunity to switch over from CPF scheme to GPF scheme solely for the living in service or retired teachers. There is no scope in the existing policy to grant any relief to the wards in this regard. This is the rejection of his representation, my lord. In terms of that, my lord, this page 63, the judgment which has been referred by my friend, my lord, you kindly seen, my lord, division bench, the instant appeal, I'm sorry, page 63, lordship. By the said petitioners who are widows of the teachers who have served under the state were allowed to obtain benefit of family pension on account of service of their deceased husbands in terms of the decision of the full bench. That is Abhijit Boido's judgment is there, my lord. Thereafter, the brief facts, my lord, for the purpose of consideration of the appeal are that the husband of each of the petitioners were teacher of the Howrah so and so. Some of the teachers died in harness and some died after the age of superannuation. Each of the teachers concerned opted for revised scale under ROPA 90 and became entitled to pension so and so. They have made the representations. Now, my lord, in this case, my lord, he has so far the deceased teacher is concerned, not made any option for CPF to GPF. Now, what you want is, my lord, that her widow, my lord, opted for that. That is why I am showing lordship the page 53, my lord. That is the rejection ground, my lord. And so far, this Abhijit Boido followed by this state's appeal, my lord. Ultimately, my lord, court holds, my lord, the respondent therefore entitled to family pension on account of their deceased husband employees. There shall be exercise option. Therefore, the petitioners are entitled on the ground of ROPA 1917. So this is the page 65 will settle that of service jurisprudence that pension includes family pension. The pension is aimed at securing the family, particularly the widow and the persons lawfully entitled to benefit from the deceased employee. So, what I asked to submit is, let considering all this, let this matter be directed the DI to exercise this, whatever anything is refundable or not, let it be calculated and grant the, and in terms of this order, let them take a final decision in this matter, my lord.
Two orders be quashed.
Yes, my lord. The judgments are there, my lord, in the view of all these judgments, my lord. And my lord, let them, because the order says, my lord, that within certain period of time.
Yes, my lord.
That has been mentioned. So, my lord, let that be, my lord. And in terms of that, my lord,
this petitioner was also a party in the appeal.
No, my lord. He has referred this.
Yeah, I have referred.
He has referred this, my lord.
But then will the petitioner be entitled if the action?
Lordship. In terms of this, my lord, judgments and all.
And my lord, 2 pages, 2 order be quashed, my lord. My lord, page 43 and 53, my lord.
So this will be subject to refund of the share.
Lordship. That has been mentioned.
Yes. Within a specified period. My lord, page 43 and 53 be quashed. Purpose on same ground. 43 and 53, my lord.
43 and
53.
56.
53. As my learned friend, my lord, Sonia Lordship, my lord. 43 and 53.
43, my lord, this has been passed in terms of the court's order. And now, my lord,
Same ground that the living teacher is entitled to option. Same ground, and therefore it has been cancelled. 53. That is the same ground. So these two memo will quashed.
now, my lord, so far page 43 is concerned, my lord, kindly takes page 44 because the 43 has been dealt with by the page 44. Honorable Justice Abhijit Gangopadhyay, as his lordship there was. However, the petitioner shall have liberty to challenge this order by filing a fresh writ application if she is so advised.
Yes.
So thereafter, my lord, he has made a representation in page 45. And subsequent thereafter, my lord, this page 53 comes, my lord.
DI না করলে DI করতে ফি বাহান না করতে
জানি
This order dated 5th June 2023 has been passed pursuant to which order?
Pursuant to, my lord, and Adhikari. It has not been, it is very difficult to, my lord. This is Gangopadhyay, my lord. It has been.
Gangopadhyay was pleased to direct the authority to consider the same. And the matter was pending.
কত পাতা
Justice Gangopadhyay, my lord, directed the my lord authority to consider reportটা হচ্ছে Justice Gangopadhyay.
Page 42, my lord, will find, my lord, the hearing notice was given. Page 42, my lord.
Yeah, hearing notice was given.
But even as to the above, hearing of the schedule to be held on so and so Friday, chamber of the DI, relevant records. So there must be some order which evidence are annexed.
কোন অর্ডার না এটা তারপর
এখানে লেখা রয়েছে an order of the honorable justice অভিজিৎ গঙ্গোপাধ্যায় dated, এটা দেখা যাচ্ছে না এই জায়গাটা। এটা কবেকার 13/6, এটা কবেকার 5/6।
23 সালে 23 দাগ বলেছিল যে পেন্ডিং রে বলো দিয়ে যে কনসিডার করো রিমেন্ডেশন আছে কনসিডার করো
এগুলো বলো।
What happened to the representation dated 18th August 2023?
No, that is page 53, my lord.
Oh.
Her representation dated 18/8/2023.
But then the order says that there is a overdrawal of salary
Yes,
by the
but
petitioner.
my lord, kindly see, my lord, page 65, my lord. Page 65, lordship will kindly takes paragraph 10.
Yes.
The respondent shall be entitled to refund the entire PF amount received by their husbands together with any so and so in terms of within so and so. Upon refund of the said sum of money, the DI Howrah is directed to forward the recommendation to the DPPG issuance of pension payment order within a specific period of time. And the DI Howrah and the DPPG shall do the with urgency. So this is there, my lord. That's what I'm saying, my lord.
In this appeal,
My lord.
what was the contention that there has to be refund of the provident fund? Why there was a direction to refund the provident fund?
Because switch over from CPF to GPF, my lord. So, my lord, he has initially non-pensionary service. Now, my lord, in terms of Abhijit Boiddo and other judgments, my lord, he said, my lord, that I have to switch over from the pension. So entire money which he has received for non-pensioning things, my lord, that has to be refunded. That is the view of the, my lord, paragraph 10, my lord.
Okay. Now, in this case, what he is supposed to refund?
That's the calculator will DI, my lord.
That has to be, that was I'm saying, my lord, at the very first instance, my lord, that has to be calculated by the DI, and thereafter, in view of the division bench, my lord, let them acted upon within a certain period of time.
There, as well as my lord, interest payable, that will calculate by the DI. Similar or my lord, only my lord prayer to impugn order be quashed only in this case. As the same is passed already after order of the honorable court. High Court.
Affidavit of service filed on behalf of the petitioner is taken on record. Next. By the present writ petition, the petitioner seeks for setting aside and or withdrawal of the impugned order under memo number 669/P/1 within bracket 7 dated 5th June 2023 within bracket annexure P6. The petitioner contains that the husband of the petitioner, namely Sudha Krishna Odhikari, was appointed as a primary school teacher under District School Board, Midnapur. And retired from service
29th March 1995.
Upon superannuation on 29th March 1995 as assistant teacher in Ramchandrapur, Ganoda Memorial Primary School, Ramchandrapur District, Purbo Medinipur. So Midnapur, District Midnapur, now Purbo Medinipur. The husband of the petitioner opted to come under the revised scale of pay in terms of GO number 33, Education, ETA, within bracket B, dated 7th March 1990 with effect from 1st April 1986, and continued to receive the revised scale till his retirement on superannuation. The order at page 43 is a order passed by the department Kumoto, or this has been passed after there was an application for grant of pension?
I believe, my lord.
Application. Application with the petitioner, my lord.
Application of the petitioner.
My lord. On the basis of application.
But my lord, at the top, my lord, with page 43, my lord, kindly see, it's very hazy, my lord. As per order of the Honorable Justice Abhijit Gangopadhyay, dated so and so, but that has, I believe, that has not been annexed.
Page 44, my lord, first para will show that. Page 44, first para. Pursuant to the order passed by this court on 1st of May 2023, the distinguished schools P. Minnapur, Puro Minnapur has passed an order after giving opportunity of hearing to the petitioner. This order is sufficient, sir.
তারপর কি বললাম? The family pension in favor. When did he die? The husband of the petitioner died on 8 June 2015. Leaving behind the petitioner widow and 4 major sons and 2 daughters. The family pension was not granted to the petitioner on the ground of overdrawal of salary, which overturns the amount of gratuity. by the impugned order. Hence this writ petition. Mr. So and so learned advocate for the petitioner. He has exercised his option under ROPA 1990.
1990.
Submits that the husband of the petitioner has exercised his option to come under ROPA 1990.
Page 19 will reveal that. Page 19. Therefore, service will reveal that.
And need not exercise a fresh option, but to get the benefit of pension is obliged to refund the government's share of contribution in her husband's provident fund. In view of the above, the petitioner is willing to refund the share, willing to refund the amount to be calculated by the District Inspector of Schools PE within bracket PE Purvo Medinipur. Respondent number
7, madam.
7, 7.
It's 8.
7.
7. Response number 7. But response number 7 is the earlier one. Who will act? 7 or 8? Seven is Paschim Mednipur, and the husband used to work at that point of time. It was Paschim.
He came Puro Midnapur.
8.
Lastly Puro Midnapur. So Puro Midnapur has been not made party, my lord. And hearing has been made by the Puro Midnapur DI.
Okay. Then 8. Accordingly,
Page
District
43 will be
Inspector of Schools,
Puro Midnapur DI has
Primary Education, Purbo Medinipur,
43.
is directed to calculate the amount required to be refunded by the petitioner to get the benefit of pension, and upon deposit of the said amount, the said respondent being pension sanctioning authority shall verify the pension papers of the petitioner, send the same to Director of Pension. Response number 5.
Response number 8 is the Puro Midnapur. Sorry. Response number 8. Response number 8 is the Puro Midnapur DI. Response number 8.
Maybe response number 8.
8.
Response number 5.
Excuse me.
Director of Pension, Provident Fund and Group Insurance, Government of West Bengal, for further steps to be taken in accordance with law for issuance of pension payment order in favor of the petitioner. The aforesaid exercise shall be completed as expeditiously as possible. Still be entitled to receive pension from July 2015 or June.
From the retirement.
Her husband has died on 8 June 2015.
Settlement of the from the retirement. From the retirement. That is the area will
From the date of retirement.
Lord, that is the settled pension law, Lord, by the special bench of the Honorable Court.
Why his husband was not receiving the pension?
No. He has not.
He has not opted for that.
Opted. He has not received the pension.
The pension shall be paid to the petitioner on and from the date of superannuation of petitioner's husband. In view of the above, disposed of.
Within period, within
as expeditiously as possible.
Kindly, Lord, period be given, Lord. 3 months or 4 months or 6 months, Lord.
No,
My
advocate for
period
the
be given,
state submits
Lord, so
that
that, Lord, I can, Lord.
in view of the willingness of the petitioner to deposit the amount to be refunded, the DI may be directed to issue to grant the pension benefits to the petitioner. The order dated 5th June 2023 is set aside. Yes.
Lord, two memos, Lord. 43 and 53 has been
43 minute already, my lord, marged into page 53 minute. Because Lordship 43 minute has been 53 is minute in terms of his representation.
Then 43 is set aside along with all consequential orders.
53.
Along with all consequential orders.
All right. Lord, time be fixed, time. Lord, 3 months, 4 months, 6 months, as you Lordship, please. Lord.
Okay, 3 months.
3 months.
Okay.
Grateful, Lordship.
3 months. Grateful, Lord.
6, I am for the petitioner, by the last occasion, it was directed by the 6th Honorable Court, my Lord, Honorable Justice Rajarshi Bharadwaj, on 2nd September 2025, directing the, my Lord, state respondent to submit a report in respect of claim of the petitioners father, my Lord, regarding retirement bills and pension benefits. I do not know whether it is submitted for us.
My lord, I have the report.
No.
My lord,
See the claim.
this is my report, my lord.
As per retirement, my Lord, on 30th April 2027, my Lord, thereafter, no such payment of pension as well as retirement dues has been given. Due to, my Lord, non-regularization of the leave period, which has been, my Lord, regularized by as per report submitted by the authority concerned. And the, my Lord, pension papers have been transmitted, my Lord, by the District Inspector of Schools to the, my Lord, District Primary School Council, Malda. And thereafter, my Lord, the Director of Pension and Provident Fund, etc., it has not released till date. The report is to be submitted.
Yes.
Yes, my lord. My lord,
this is not the correct submission. There is a two part. The father of the petitioner was a primary teacher under the Malda District Primary School Council. Father, he had absenting from duties. Father, 730 days at a stretch, which was condoned. If your lordship kindly have come second page of the the order of the decision of the District Primary School Council, second page, they have condoned sanctioned 730 days extraordinary leave in favor of late Uttam Kumar Misro, and the rest 195 days leave taken by Uttam Kumar Misra relegated to the Commissioner of School Education, because ultimate decision would be taken by the Commissioner of School Education.
Whether
Accordingly,
to condone the breakup?
No, because as per Geo referred Geo 136 EDN 7-1 12 months would be condonable upon satisfaction on production of the documents that cogent document that the teacher concerned was prevented due to such reasons. But here, delay is another delay is 14 months 6 days. Already 730 days condoned by the council. Rest 195 is wrong. If your lordship kindly have a look, the period break period is last break period is February 24th February 10 to April 30th 2011. It would be 14 months 6 days. Commissioner of School Education take a decision on 5/5/25 that this period cannot be condoned in terms of para 7I of the Geo 136 EDN 19. That is DCRB rules. Either either the petitioner has to challenge that decision of the Commissioner of School Education, because in the prayer there is no such in the prayer portion of the writ petition that there is no indication that for sanction of the long period of absence there is no prayer in the writ petition. Either he has to challenge this memorandum, or the authorities is not in a position to condone this period of last period of delay.
Okay.
This matter on behalf of the council has been made by Advocate Abhishek Prasad Bachchu. I have been instructed to pay for a fortnight time since due to his mother's operation is not in Calcutta.
As per communication,
I think decision of the council I have annexed with my report are two. This is the decision of the council, that is DPSC Malda. They have relegated the Commissioner of School Education. Commissioner to School Education has taken decision in view of paragraph number 7-1 7I. I have the gadget. I have the virtual card. If you lordship kindly have a look in.
Can you just clarify what does this mean? You see, as per para 7.1 of Geo number 136 EDN B, dated 15th May 1985, only a break in qualifying period may be condoned. Correct?
Yes.
So this has been condoned by the council.
Malad, first part, 730 days.
Wait. But as the incumbent's date of superannuation was 30th April 2011, the aforesaid period cannot be accepted as break-in service.
Yes.
What does this mean? Cannot be accepted as break-in service? If there is no condonation, then there is also no break-in service.
No, my lord. After condonation, that period regularized 730 days. Then, my lord, there is no provision for sanction of any type of leave. Then matter relegated to the Commissioner of School Education. My lord, 7I contemplates that, my lord, if there is absent 12 months, that would be treated as break-in service. That period can be condoned by the commissioner. This is, my lord, kindly have a look or kindly.
Monitoring. 7-1 you're carrying.
My lord.
Break-in service, that is not the, my lord, stated, my
My
lord.
lord, kindly have, my lord, kindly condone me. My lord, this part, my lord, 7I. Break-in qualifying service. This is the memo. I have indicated that part. The I. Break-in qualifying service of an employee for a period exceeding 12 months shall entitle forfeiture of his past service unless the break is condoned by the competent authority, that is director or any authorized by him. Break in service not exceeding 12 months would be treated as automatic condone.
Here it is.
But here, my lord, 14
stated it cannot be accepted as break-in service.
14 months, 6 days. If it is within 12 months, then it would have been treated as break-in service. That may be that was condonable period.
So the aforesaid period from eto থেকে
Yes.
eto cannot be accepted as break-in service.
Yes, cannot be, because this period is 12.
This period cannot be treated as break-in service. It is informed.
It is exceeding 12 months, 14 months, 6 days. Please calculate it. তুমি ক্যালকুলেট করে দেখো।
এটা বলেছে যেটা সেটা মানে বোঝাচ্ছে এই পিরিয়ডটাকে
কন্ডন করা যাবে না, করা যাবে না। Yes.
break-in service
Cannot is correct. Because I am not understanding. Because
my lord,
one
yes,
part
my lord.
he says that I cannot condone the leave. Now it cannot be condoned. Now he also says that it cannot be treated as a break-in service.
My lord, why it was written, I don't know, but the meaning would be, my lord, if it is within 12 months, that would have been taken as break-in service. If it is beyond 12 months, that would not have been treated as break-in service.
So what will be this leave will be treated as
Yes,
what?
14 months, 6 days, lease would not be treated as break-in service. So there is no provision for condonation. There is no provision for condonation. My lord, kindly come to last. My lord, kindly 4, my report 4. The order of the commissioner.
No, again I come back to 7I.
cannot be
7I.
accepted as break-in service.
Break in qualifying service of an employee for a period exceeding 12 months shall entail forfeiture of his past service.
My lord.
Unless this break is condoned by competent authority. That means the competent authority, if it exceeds 12 months, can condone and regularize his service. Correct?
My lord.
Break in service not exceeding 12 months would be treated as automatically condoned. The council has condoned his delay for 12 months, meaning thereby, as per 7.1, it is automatically condoned.
No, my lord. Council has the authority to sanction, my lord, extraordinary leave, medical leave, casual, all leaves are exhausted. My lord, council has the power actually 24 months. In spite of that, council condone it 730 days. Council part is over. 730 days already been almost 2 years condone, because it is the authority of the council to condone up to 24 months. That is 730 days condone. Rest part is 24th February 2010 to 30th April 2011.
Yes.
That would be decided by the commissioner. Kindly come to last annexure for page 4 of my report, annexure 2, part 2. In reference to the above, I have intimated to the council, my lord. This is to inform you that Uttam Kumar Mishra remained absent in the school on and from 2008 to 2011 when he attained the age of 60 years. The district primary school council Maunda, BTS memo dated such and such, has sanctioned extraordinary leave without pay for the period of 24th February 2008 to 23rd February 2010 and forwarded the remaining period with effect from 24th February 2010 to 30th April 2011 to this directorate to treat as break in service and also to declare the same as condone. As per para 7I of GO number 136 EDN dated 15/5/1985, only a break in qualifying period may be condoned. But as the incumbent date of superannuation was 30th April 2011, the aforesaid period 24th February 10 to 30th April 2011 cannot be accepted as break in service. Therefore, this period cannot be condoned. This is for your information.
I just need a clarification to this sentence, but as the incumbent's date of superannuation, what is to do with superannuation date?
Because the last date, otherwise, how the total absenting period would be calculated. Unless the date of superannuation is taken into account, the period would not be calculated. That is why there is two part. One part already been condoned, and second part. My understanding, I may be wrong, that it is exceeding 12 months. That is why commissioner.
No, what is break in service?
Break in service 12 years without any leave, sanction of leave. If the teacher concerned was absent, then it would be treated as break in service. Then he would not be entitled to
So
get
why
pension.
does it say that the aforesaid period cannot be accepted at break in service? It is more than 12 months.
More than 12 months.
Then why it says that it cannot be accepted break in service, therefore the period cannot be condoned? If the period is not condoned, then there is a break in service.
Break in service.
Then why it says it cannot be accepted as break in service? Does acceptance of break in service is regularization of the leave and condonation?
Yes.
Because these two cannot go together. What I understand. That's why I'm asking
Language
what is break in
confusing.
service?
Language is confusing, but the memorandum is clear.
Yes.
Memorandum is clear. My understanding is, since it is 14 months, more than 14 months, that is why the commissioner refused.
As per 7.1, it cannot be condoned.
Yes. That is, it appears from the memorandum. But language, there is mistake, I think.
Cannot be details. Cannot be condoned.
When is Mr. Prasad coming? He has not come to court today. Okay.
Because at this stage, the council do not have any function. Because all.
Then you take the clarification, because if it is cannot be under the law as existing, if cannot be condoned, then petitioner has no relief in the writ petition. Because it exceeds 12 months.
12 months.
Now, under what circumstances exceeding 12 months can be condoned by the officer concerned? Because it also gives a liberty to the officer to consider whether it can be condoned or not.
And the council has submitted all the papers to the authority concerned.
Yes,
for
yes, that is
releasing pension.
undisputed, undisputed. My lord, I will
After
take
communication from the commissioner.
clarification from the commission of school. Kindly indicate it. My lord, I will take some clarification. Kindly indicate it, my lord.
The report filed by the state is taken on record. Mr. Chattopadhyay, you've given a copy?
My lord,
copy of this report?
I have already handed over.
Copy served. Mr. Arindam Chattopadhyay, learned advocate for the state, submits that since the certain portion of the absence have been condoned by the Malda District Primary School Council, particularly 730 days of extraordinary leave. And the rest of the absence of the petitioner has been referred to the Commissioner of School Education, Government of West Bengal, for consideration. As per para 7.1 of GO number 136-EDN within bracket B dated 15th May 1985, since the period of absence from 24th February 2010 to 30th April 2011 exceeds 12 months, hence the same has not been condoned. However, he seeks some accommodation to take further instruction from the authority concerned. Accommodation is also paracore. Accommodation is also sought for on behalf of your respond number.
The council.
Respond number 5. 5. Release this matter after 2 weeks. Do shopte for under the same heading.
We appear for 4 and 5.
Appear করছে 6 accommodation.
Hobe next.
2 weeks after 2 weeks. কবে আছে ডেটটা বলে দিন। 19th
19th 19th
I'm for the petitioner. But family pension. But I am appearing on behalf of an unmarried daughter of the teacher who died prior to 1981.
Prior to
1981. That is the benefit death cum retirement benefit scheme 1981. When that was came into effect, but prior to that, the teacher was died. Now thereafter, the mother, that is the wife of the teacher, was getting the family pension in terms of the pension payment order issued by the authority.
mother was getting widow. Widow was getting the pension.
That is from 2012 to 2022. Because in 2022, the mother of the petitioner, that is the widow of the deceased teacher, was died. Thereafter, the petitioner made an application after the death, being an unmarried daughter, made an application for granting family pension. That was turned down by the impugn order, page 29. Relied upon the circular dated 539.
Page number? Page number?
Page number 29. Relied upon the government order 539. Now the main the main reason recorded in the 539 government order that only after 1981, if the ex-employee was in living or his my lord, the widow can get the benefit of the family pension. That was the 539 government order. Well, that was my lord challenged before the Honorable High Court, and a larger bench was formed. And larger bench held no, that can also be benefit can also be given to the unmarried daughter. That is the larger bench judgment. Now, in that order, in that my lord judgment, you will see first. Please have a look. The government order dated government order number 539. That has been my lord, page number 8. That 539 government order has been recorded.
Which is the other one? Geo.
That is my lord date. That is not relevancy. That is the date when my lord the benefit can be given. That is the my lord Geo 883.
Geo.
But main government order is 539.
It is in the same difference to. And what is Geo 883 AC?
Geo 883 only my lord
issued
recording the date from which my lord the family pension can be given.
Okay.
But main government order is 539. Paragraph number 3, page 9.
Plus 6. Page
Number. My lord, kindly have a look the paragraph number 6, page 10. Well, that is enough. The benefit should be extended only to the living ex-employees. Paragraph number 6. The benefit should be extended only to the living ex-employees as mentioned in under para 3 above or their living widows as the case may be. So 539 can only be given benefit of the ex-employee. That has been stated in paragraph 3. Employee number B. Those employees who retired prior to introduction of the 1981 pension scheme but render more than 1 year approved qualifying service but less than 10 years approved qualifying service. Now, you will see, please come to straightway, page number 13.
Page number
13, 1-3. Now please have a look, page 13, from the bottom paragraph. From the memoranda, page number 13, 1-3, from the bottom. From the memoranda as above, it is clearly explicit that the legislative intent to extend the benefit of the pension, family pension, to the unmarried widow, divorced daughter of an employee who retired before or after 1/4/1981, or to unmarried widow, divorced daughter of an family pensioner. In such premises, the memorandum dated 1st November 2010 should not stand in the way of extending such benefits in the absence of any express provision therein restricting or affecting the benefits. Socio-economic justice stemming from the concept of social morality. If pressed into service, the memoranda granting social security of livelihood to the aforesaid classes of women by providing family pension should be construed liberally. Some isolated terms in the memorandum dated 1st November 2010 providing pension to living employees or their widows, in our view, cannot restrict the benefit provisions contained in the memorandum as above. Therefore, we answer the reference to this extent that the benefit of family pension can be extended to the unmarried widow daughter of an employee who superannuated or died prior to coming in force of Death cum Retirement Benefit Scheme 1981, which came into effect on and from 1st April 1981. So, Honorable larger bench has given the answer that the benefit can be extended to the unmarried daughter of the concerned teacher who died prior to 1981. But this order was challenged before the Honorable Supreme Court. And Honorable Supreme Court also dismissed the SLP. This is the SLP order. That is at the top, MAT number 1518 of 2019. And you also may find the larger bench judgment at the top, 1518 of 2019. Now, relied upon another writ petition was filed before this honorable court by another person, another petitioner, who are on the same footing. Now, that writ petition was dismissed. Against that, my lord, they preferred intercourt appeal, which was also allowed by the honorable division bench. Well, that is the judgment. The similar point involved here.
Yes.
Kindly have a look.
Lordship. Lordship, so far law is concerned, this is settled as per the notifications. But so far actual aspect is concerned, the petitioner's father, who died in harness on 4th of December 1973, and in consequence thereof, family pension was extended to widow. And widow enjoyed the family pension and died on 20th of May 2022, leaving 3 sons, 2 daughters. One daughter is married and petitioner is the other daughter. But this petitioner had been working in ICDS on contractual basis, and he retired therefrom on 31st of January 2023. Thereafter, having come to learn of this full bench order, he has applied for. And therefore, now his contention, her contention is this, that I was a contractual employee. I have no pension or other things. That's why I cannot maintain my livelihood, and therefore family pension may be extended to me, since it is there as per the latest notification that it would be extended to the unmarried daughter till he marry or till her death. This is the thing. Now considering this factual aspect, can you pass the order?
Now, so far the contractual basis employee that
You
might.
completed.
Lodge. What else? Sir?
Now the last judgment I place before your lordship, please have a look. The judgment of Linda Mukherjee. That is the last judgment I placed before your lordship. Yes,
No report perhaps has been called for.
paragraph number 4. The same thing was happened in that matter also. Learned counsel on behalf of the appellant submitted that the appellant was working as an ICDCS worker on a contractual basis and she superannuated from her service on 3/4/2022. And as she was a contractual employee, there is no question of granting retirement service benefit as like the government employee to get pension. It is further submitted by the learned counsel that after the end of the contractual employment, this appellant has no other source of income by which she can maintain her livelihood. As per submission of the learned counsel, that the authority concerned rejected the application of this appellant only on the ground that her father was a teacher of a school and was not under death cum retirement scheme 1981. This appellant, being the unmarried daughter of the deceased father, is entitled to get family pension. And the next paragraph is very important. Paragraph number 5. At the time of hearing, learned counsel further submitted that the learned single bench, by the bypassing the impugn order, committed error in holding that the family pension cannot be given as it is paid after a gap of time. It has been already held by the Honorable Division Bench in that matter. And after considering the judgment of larger bench, pass the paragraph number 9, page number 6. In view of above facts and circumstances, in view of above observation of the larger bench of this court, the order impugn is not maintainable and accordingly the same is hereby set aside. The respondent number 2, District Inspector of School Primary Education, Purbo Bardhaman, is directed to revisit the representation made by the appellant dated 13/2/2023 in view of the observation made by the larger bench in the case of State of West Bengal and others versus Sobhita Rai within a certain period.
But in my humble submission,
Yes.
my humble submission is this, below. Respondent should be granted a liberty below to file a report. On the basis of the report below, considering the provisions of law, lordship can pass forward. That would be better below, in my humble submission. Okay. As because law is settled, but the factual aspect may be different. That's all.
For my humble submission,
And there cannot be any state jacket
the impugn order and directed the authority to revisit the matter in terms of the judgment as I referred before your lordship. And there is already direction to file the report that they have not complied with.
There was a direction.
Yes, there was a direction. 27 January 2025.
You are representing District Inspector of Schools.
Yes.
Lordship report, direction was there for report.
Yes.
Yes.
But practically my junior is not here, Kinkor Bhattacharya. Perhaps he appeared.
In January 25, the order was passed to file a report through the District Inspector of Schools.
Yes, that report is not with me. Perhaps it is that it is with him also. And that's why either Lordship will grant time to directing him to be here, or below fresh report.
No report has come, so there is no question of
Perhaps that is there.
of that order. You have to comply that order.
I mean, he has not come to court, perhaps. That's why today, that's why what I am submitting. Also, can we adjourn the matter for another day while he would be here and report would be submitted?
Mr. So-and-so, learned advocate for the petitioner. submits that the petitioner is the unmarried daughter of the deceased who prayed for grant of family pension in her favor. The prayer of the petitioner was rejected vide memo number 535 dated 10th August 2023, which is challenged in the present writ petition. Which is challenged to Poradin on the ground that clause number 6 of the GO number 539-AC within bracket P and B dated 1st 11/2010 only extends the pension benefits to the living ex-employees as mentioned under para 3 with bracket clause para 3 above or their living widows as the case may be. As the case may be. The question as to whether an unmarried daughter of the deceased is entitled to family pension has been answered by the larger bench of this court in Mat 1518 of 2019, along with other batch of appeals and writ petitions. He seeks for appropriate direction upon the authority concerned, namely District Inspector of Schools, Primary Education, Purbo Bardhaman, to revisit the issue in the light of the decision passed by the larger bench. Maternity to State versus of West Bengal and others versus Shobita Rai. In the light of light of a larger decision, in the light of the decision of the larger bench in Shobita Rai Supra. At this stage, learned advocate, Mr. Swenson, learned advocate, seeks to file report in terms of direction issued by this court on 27 January 2025. Let such report in the form, let such report be filed by the District Inspector of Schools, Primary Education, District Purbo Bardhaman, response number 2, in terms of order dated 27 January 2025, within a week. Within a week, you file a report. Is this matter? After 1 week, পরে কোথায় যাবে? 1 week পরে under the same head.
Next Tuesday, next Wednesday. Tuesday. Next Monday. Next Monday.
11th.
11th.
Tuesday.
Malad, except any day, malad 11, malad.
Except 11th?
Except 11, malad, kindly give any day. 10th
Then
or
you're not 12th?
12th. Grateful to you.
Lord, I have already served upon all the respondents. This is the affidavit of service. Affidavit of service. Well, here is the case. The petitioner is a widow daughter. Now, the petitioner's father died in 1988. And date of issuance of the PPO has already been issued. Thereafter, the father died. After father died, mother was getting family pension and other benefits in the year 2010. Now, in 2017, the husband of the petitioners had also died. So thereafter made an applications for granting family pension. So according to the government memorandum on 30th April 2010, she is entitled to get that benefit of the family pension. Now your lordship, my lord, kindly ultimately pursuant to the court's order of this honorable court, the Director of Pension Provident Fund and Group Insurance has already been an order passed. That is page 29.
Right. Widow daughter of
First of all, the page 25 is the government order, that is 30th April 2010. Where is the widow daughter and unmarried daughter is entitled to get their family pension, and thereafter, my lord, the petitioner has obtained that income certificate from the competent authority, that is, my lord, up to the cutoff of 3,500. Now, pursuant to the court's order, that is the limit of the, my lord, family income is family pension is to be paid out up to 9,000. Now, that is, my lord, thereafter, my lord, the direction has been given by this honorable court as page 31 by an order dated 27 September 2024. According to this order of my lord Justice Mantha, the 27 September 2024, the Director of Pension Mallet has already been order passed. That is, relevant page is 36. Therefore, considering all the relevant records and documents in compliance with the honorable court's order, prima facie, I am of the view that the petitioner is entitled for family pension as widow daughter if otherwise eligible under GO number 96 ACB dated 13th April 2010, along with the other memo dated such and such. District National Schools P. Nodia is directed to send the pension file with all relevant documents within 2 weeks of DPGP, and the concerned cell of the DPGP is directed to issue PPO within 1 week thereafter. After that, my lord, the PPO has been issued. That is page 38. Now the petitioner is claiming for the area where the, my lord, the petitioner is entitled on and form, my lord, that is date from the date of 15th March 2024.
15th March?
Area.
15th March?
15th March 2024. Para 6 of the writ petition. Only area with interest.
Comma sir.
15th March থেকে till the date of actual payment.
27 নয়
27 নয়
15 মার্চ কোথায় পেলেন দাদা?
না till date হবে actual payment হলে
Oh, that is different.
the area, because she is getting pension.
He is getting pension.
My lord.
Of?
My lord, for family pension.
My lord, kindly come to last annexure, page 38. My lord, last column, we effect from 27 September 2024.
Yes, yes. That was calculated of that my lord, extension of income ceiling limit by an order dated 27 September 2024.
Consider.
So it will be from 15th March 2024 or 27 September 2024. What will be the area?
March. But my calculation is 15 March 2024. Because 15 March is the date of applications. That application has to be considered, but due to litigations of this honorable court as well as the order passed by the DPGP, then my lord, DPGP has been decided on 27 September 2024, where the date of issuance of the order for extension of income ceiling limit. Because adjudicated by the competent authority on and from 27th September 2024. Even my lord, page 37, that is also my lord communicated, and 38. 38 is the my lord DPGP's my lord issuance of the family pension, that is Osimia Pramanik, 6th May 1968, daughter widow. Family pensions up to 383. From 27 September 2024 to that nil.
9,000.
So she is entitled the arrear pension with effect from 5th March 2024. 5th March 2024. That is my lord.
But it appears from the writ petition, no documents in support of his claim. 5th March 20, I could not, why he is claiming on that day SDO issued income
Yes,
certificate.
that is
Wait,
adjudication.
it appears, the decision of the director of pension that she is entitled for granting pension on 27th September 2024.
Well, at page 27.
Entitlement would be decided upon verification of all
the
things.
documents.
It is the date on 27, but he did not annex a vital document when the pension was credited in her account. That should have been disclosed because.
My lord, kindly see, my lord, the pension was my lord, not granted because there is no any my lord, the income certificate. Whereas page 27, you'll also kindly my lord, one second.
Where is the income certificate dated 15th March 2024?
15 March 2024.
Where is that?
27.
Page 27.
27.
Page 27. Issued by the Sabinal officer, Krishnagar, Sadar Nodia.
This is one of the requisite documents. Other documents are also required. This is one of that document.
Yeah, thereafter, the residential schools my lord, having my lord, pension provident fund has been issued to the DI. Page 28. It has been under process. Then 5th August 2024, senior law officer of the pension department has also been secretary of the school education department.
28.
What is the
Entitlement of
arrear
family
then?
pension.
What are you getting and what is the arrear?
Only arrear.
Arrear from which date?
Arrear with effect from the adjudications of the SDO, whereas the certificate is issued in favor of me on and from 15 March 2024.
On and from 15th March, you are getting 5,000. 5,000. Now, what is the arrear then?
Arrear my lord, that is 9,000 has been my lord, issued by the
9,000 has been issued. This will take effect immediate from date of issue of this order.
You'll kindly see the
It
page
will be
31.
calculated from 27th of September 2024.
Yes. Well, this is the pension payment order. It appears 27 September 20, her entitlement with effect from 27. This is merely a certificate issued. Somebody claim certificate of income that was issued.
The date of the
In
order.
relation to the PPO, this is not related. This is not any documents of pension payment related to pension. It is the one of the criteria when she is claiming widow daughter pension. Then she has to submit certain documents, including income certificate, no liability certificate, no objection certificate. All documents, 5 to 6 documents are required.
Then you also 27 September.
He did not annex the
pass this order by granting arrear along with the interest.
When he
up to till date.
She got it.
It has been
It should have been disclosed.
No,
When?
DPGP has already been order passed. Page 35. Page 35.
Where is the claim made to the department?
Yes.
Have you filed any representation before the department?
Order has already itself says. Page 36. This is the Director of Pension, Provident Fund and Group Insurance.
Page 34 or
36. That is the order. Last portion. Therefore, considering all the relevant records and documents in compliance with the Honorable Court's order, prima facie, I am of the view that the petitioner is entitled.
Did you file any application before the department concerned seeking for arrear?
No, that was not done, but process was done and order was passed by the Director of Pension, Provident Fund and Group Insurance, and thereafter the motion has been filed. Your lordship has been disposed of this matter with the directions for adjudication on 27 September 2024. CJ, that to get
one document shown to your lordship, page 30. It is in connection with contempt application, page
Yes,
37, this is the documents of 9th December 2020, but she is entitled before that. What he is submitting, but this document, this order was passed on 9th December 20.
Considered by the Director of Pension.
Yes, with effect from
After
27.
careful hearing of the Honorable Justice Rajasekhar Mantha has passed an order dated 27 September 2024 in CPN number 924 in WPA number 4117 of 2019, which inter alia states, in the view of the matter, the DPGP West Bengal shall first take a decision as regards the entitlement to pension of the petitioner only given her income. Let a regional order be passed in that regard. So pursuant to this order, my lord, in connections with the contempt, this order was passed. So there is no any dispute.
This order was passed on page 37 on 6th of December 2024. This order was passed. He should have placed the date of order. Date of order is 6 December 2024. With effect, effect was given 24th September.
This is the memorandum issued.
When she got the pension, that should have been disclosed. The bank document when the amount was credited, that is the vital date. Otherwise, from the date of issuance of pension, that is 27 September 2024 to the actual payment, that has not been disclosed.
Well, by Laden Fed ballot has to be read out in this page 31 as order passed on 27 September 2024. Your Lordship, kindly once again,
In connection with the contempt application.
Yes, in connection with the contempt application, because it has not been complied by the respondent authorities.
But this honorable court never
after issuance of the order, the DPGP has been taken decision or passed a region order. That region order to be given effect to.
Yes, that reason order was passed on 6th of December.
My learned friend has been taken that how the petitioner is entitled to get that all documents, even after having all documents has been considered.
I think
there is no any dispute.
In support of DPP.
There is no dispute. In supporting of this DPGP, the order was passed. Because it has been communicated to the petitioner.
This order was for 6th of December, page 37.
6th of December, that is 9/12/2024, is the communication to the petitioner and other authorities.
Ordering part,
that order.
Page 37, ordering part. I am of the view that the petitioner
connection
entitled
with
to
all
family pension, widow daughter, if
containing with the order. That was informed. That was informed to the petitioner along with the other
27
authorities.
September 2024.
That is 6th December 2024.
In the contempt application, there is a mention of a circular dated 9th November 2023.
9th November 2023. It has been enhanced limit, ceiling limit of monthly family income from 3,500 to 9,000 per month to the dependents of a deceased employee. Only unmarried daughters are directed in the said circular. In that view of the matter, in the 5th line of the 2nd paragraph of the 1st page of the order dated 20th, it has been clarified by my Lord Justice Mantha. And also in terms order passed in terms of the division bench order passed in MAT 1518 of 2019. It is a special bench judgment.
From 27 September, what is the amount you are receiving as pension?
Well, 9,000.
And what is your difficulty?
My grievance is from the date of effect of that adjudication to arrear along with the interest. I have nothing to say in this writ petition because I am getting the pension.
But this cannot be given a retrospective effect.
Retrospective effect on 27
The enhancement in the ceiling limit cannot be given a retrospective effect.
Enhancement is
The order has not been challenged.
Because the 15 March 2024, the SDO has been having inquiry that after issuance the certificate of the family income. Now family income certificate of 3,500 has been enhanced subsequently in 9,000. Now after that, pursuant to the court's order, only that pension payment order is issued. Now pension payment order, the petitioner is entitled to, is getting the pension. Now, this writ petition is filing only claiming to area, to get area. So, my lord, I am praying on and from 15 March, when the order was passed or certificate has been issued.
No.
Now, my learned prayer has been, my lord,
How can you claim arrear when the order has been given effect from 27 September 2024? And the contempt applications order has also been
27
complied with
September.
by taking into consideration that notification,
Yes,
which records. You come to page 36.
Same thing.
It records that the petitioner may be entitled to family pension as widowed daughter with effect from 27 September 2020.
Your lordship, my lord, passed this order on 27 September.
Nothing remains in the
He
writ.
relied upon this order again. Is not SDO certificate. I am putting question myself. A competent authority issued certificate in favor of a person, whether that creates any equity that on that day she is entitled to pension. How? What is the basis? What is the law? I am putting question myself.
Then, my lord, page 36 of the DPGP.
He relied upon the
Director of Pension Provident Fund Group Insurance has been order passed as per order of the Honorable Court. This is the order, page 36.
My lord also relied.
That he is entitled to get that pension, family pension. Now, family pension has been, my lord, carried out by the authority. That is page 38.
He has not challenged that decision. On my lord, it has been clearly.
Where is the decision?
stated
My lord,
dated
that
27
decision is
September
connection with the
2024.
contempt. That decision has already been taken out by the authority in connection with the contempt, passed by Lord Justice Mantha. Now, in page 36, the last order, there is the regional order, was passed. My lord, 1 second, my lord, may I read it? Therefore, considering all the relevant records and documents, this order has been passed in connection with the contempt. Therefore, considering all the relevant records and documents in compliance with the Honorable Court's order, prima facie, I am of the view that the petitioner is entitled for family pension as widow daughter, if otherwise eligible, and GO number 96 ACB dated 13th April 2010, along with the other GO dated such and such. District National Schools P. Nodia is directed to send the pension file with all relevant documents within 2 weeks to DPGP, and the concerned cases of the DPGP is directed to issue PPO within 1 week thereafter. My lord, after that, pensions payment order was issued by the DPGP in connection with the PPO that was not annexed in this petition, only for intimation in regard to the DPGP, page 38. That 383 of the family pension on and from 27 September 2004 to till nil. That was issued. So I am not denied and dispute that.
Why are you claiming your arrear in view of the notification 96?
If your lordship, my lord, either 15 March 2024 or 27 September 2024.
27 September, you are getting it. There is no question of any calculation of arrear.
Lordship, I have
My lord, your lordship.
instruction from the DI Lordship in support of the rescind order passed by the DPPG. Lordship, she is entitled to the pension from the date the circular was issued, that is on 27 September 2024.
And she is getting that.
Yes, your Lordship, I have received written
Assured.
instruction.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction upon the respondent authorities to release the arrear of pension with interest at the rate of 10% per annum in terms of government circular number 96 AC within bracket B dated 13th April 2010.
15 March 2024 to 27 2024 এমন dispute
This is second round of litigation.
তোমার একটা dispute হবে তোমরা 1 বছর করে রিলিজ করো রিলিজ করুন না রিলিজ করলে তো আমার বেনিফিট বাইরে ভোগে যাবে মামলা থাকা না থাকা
The petitioner is a widowed daughter of Kanailal Sadhu, who was an employee of Nodia District Primary School Council and retired from service on 31st October 1988, and subsequently died on 30th January 2005. After the death of the husband of the petitioner, namely Manoj Pramanik, on 7th November 2016, the petitioner made an application before the District Inspector of Schools on 11th August 2017 for grant of family pension. The prayer of the petitioner was turned down by the authority concerned. The petitioner, being agreed by the said decision, the petitioner filed a writ petition before this honorable court, being WPA number 4117 of 2019. At paragraph, the said writ petition was disposed of. Order date, order passed in the writ petition, page number. The writ petition was disposed of.
কপি দিবে এটা কি ফ্যামিলি পেনশনের কপি নাকি পিও এটা তো ক্যাটাগরি অফ ফ্যামিলি পেনশন অ্যাজ টোটাল উইডো কিন্তু দিতে হবে তোমার 283 টাকা 330 টাকা
6 থেকে 12 with the following direction.
9000 টা 9000 এর রিপিয়ার করে ওইটা দেয়নি নেক্সট করে কত ভাবছে
ওই ডেটটা কি বললাম যে কবে রিজেক্ট করে দিয়েছিল না ওই যেটা ওই যে ডিস্ট্রিক্ট ইন্সপেক্টর স্কুলস ওর অ্যাপ্লিকেশনটা এ করলো 22nd সেপ্টেম্বর 2017 একদম একদম যে অ্যাপ্লিকেশনটা করলো নিজের হাজবেন্ডের ডেথের পরে হ্যাঁ ওইটার পরে
পূজা লিখছে তাই তুমি বলছো না আমি এডুকেশন পেয়ার করতে পারি
22nd সেপ্টেম্বর 2017
কতগুলো যাইতে পারতো অ্যাপ্লিকেশন আছে এডুকেশন 15 মাস কতগুলো যাইতে পারতো অন্যায় কিছু চাইনি
একটা প্যারাগ্রাফ নাম্বার দেবে since the order passed in the writ petition was not complied with, the petitioner filed a contempt application being CPAN 924 of 2024.
গ্রেড হয়ে যায় ইপিএসসি করার সঙ্গে সঙ্গে 800 জন মধ্যে গ্রেড হয়ে যায় এখন
কি জানি কি পেয়েছে কি পায়
দেয়নি বলে তুমি জানো
আরে ও তো বলবে সাপ মানে মাথার চুলের থেকে পায়ে
The said contempt application are disposed of
22 বার ধরে কাটে
with the following direction. 7 to 7 and 8, পেজ বলে দাও পেজ 32 আর ওই অর্ডারের ডেটটা হচ্ছে অর্ডার পেজ নাম্বারটা হচ্ছে 21
ইনসান পাস
Pursuant thereto,
এত ভালো আছে
order has been passed
ভিতরে ঢুকতে হয়
by the
ভালোবাসে কি
Director, Pension Provident Fund and Group Insurance Government of West Bengal. On what is the date of this order?
তাহলে এটা
On
is the order passed on already the containing page 34
35 order dated
35 order dated that is my lord
9th December 2024.
9th
9
December
12 2024.
9th December
That is
2024.
annexed in my report, Your Lordship.
37 is also my lord appear 9th December 2024
ওপরে না affidavit সার্ভিসের পরে next paragraph করুন District Inspector of Schools Primary Education Nodia files report dated 26 May 2025 which is taken on record. 9th December.
Second page of my instruction.
Yes, sir.
The petitioner, para, claims arrear from 15th March 2025,
24.
15th March 2024 on the day on which the subdivisional officer Krishnanagar Sodor Nodia has issued the income certificate. By order number 1240-ACD-11011 within bracket 11/4/2024 dated 27 September 2024. The income ceiling for entitlement of family pension for divorced/widowed daughters were raised to rupees 9,000 per month. Such order was directed to take immediate effect from the date of issue of the order. The director is respondent number. The respondent number, director 2, Director of Pension Provident Fund and Group Insurance, Government of West Bengal. While allowing family pension in favor of the petitioner, has considered the memorandum dated 27 September 2024 and allowed the petitioner to entitlement of family pension as widowed daughter with effect from 27 September 2024. That is the date of issuance of the order for extension of income ceiling limit. Since, as the order dated 27 September 2024 expressly provides that the extension of the income ceiling will take effect from the date of issuance of the order, the same cannot be given a retrospective effect as claimed by the petitioner from 15th March 2024. In light of the above, the writ petition falls short of merit. According to writ petition WPA 10331 of 2020 stands dismissed. All connected applications disposed of in interim order. क्या था क्या interim order? এইটা affidavit submit.
নাম দিয়েছিল
Your what? Last date also you have taken adjournment.
Learned advocate for the petitioner is not well. I'm not the advocate on record, Lordship. Learned advocate for the petitioner is not well.
What is your name?
Pita Shaha.
Huh?
Urpita Shaha.
Miss Urpita Saha, learned advocate, seeks accommodation on ground of inconvenience of the learned advocate for the petitioner. State is unrepresented. Release this matter after 3 weeks under the same heading. Neil? None appears on behalf of the petitioner, nor any.
My lord, I am for the petitioner, my lord. My lord, I am for the petitioner, my lord. In item number 10, I am for the petitioner, my lord.
Yes. Affidavit of service.
My lord, if affidavit of service will be submitted if your lordship allow during the course of today's lordship proceedings, my lords.
What today? Who will hand over the affidavit of service?
My lord, my junior will hand over it to.
So nobody is here physically.
Well, my lord, actually the affidavit of service is not present right now, my lord.
Petitioner.
Hand over it.
Miss
My lord,
Priya,
kindly give the matter, my lord.
petitioner to appearing through virtual mode seeks accommodation to file affidavit of service. This matter after 2 weeks under the same heading.
My lord, kindly fix a short date, my lord. Due to my gynecological problem, and I'm not present, my lord.
19th, 18th. 18th.
18th. Grateful, my lord.
After this. This is your matter. Next.
Next.
11 forward document. Is it ready? Other side is present.
Other side
And
is
for the
here.
DPS sealers.
Yes.
Date is answering.
It is ready for hearing. They have filed their report.
I am for the state.
11.
11.
Lots of
Take
before going
instructs.
to the
You are for your
state.
Sir, you are for?
I am for the DPS sealers. Birbhum. District Primary School Council.
lots of the matter is the petitioner is a retired teacher of a primary school. Now, lots of the retired in the year January 2024. Now, lots of the petitioners submitted all relevant documents, petitioner's service books, and everything has been submitted. Now it has been returned. Returned on the fact that the pension and sanctioning authority has not approved a category scale. So petitioner is entitled. Petitioner completed the basic training for the sessions 2005 and 6. Result published in the year 2011. Now, Lordship, this issue that who has completed the training, 1 year training for the session 5 and 6, and the Lordship, the examination could not be conducted due to several court cases up to the Honorable Supreme Court. Now, examination held in 2011. Now, 2011 petitioner declared the petitioners completed the PTTI training, Lordship, the 1 year's training. Now, this issue has went up to the Honorable Division Bench. The Honorable Division Bench pleased to hold the yes, who have completed the training for the session 5 and 6. Now, Lordship, they are entitled to get a category scale.
Okay.
Now, Lordship, the petitioners, Lordship, the subsequently issue has been, Lordship, cropped up that since when a category scale has been entitled. Now, this issue already has been decided by this Honorable Coordinate Bench. The petitioner is such type of candidates entitled to get a category scale from the completion of the examination. Now, because due to court cases, result published in 2011, for this reason, the such type of, Lordship, the beneficiary cannot be deprived. Now, Lordship, I filed a writ petition. Now, Lordship, in the writ petition, initial writ petition was, Lordship, the interim order was passed, directing the respondent to file an affidavit. Now, Lordship, state has admitted that yes, I am entitled to get the retirement benefits with a category scale
but it will be from the
2011.
from 13. So according to them, 13.
Okay.
Now, Lordship, this interim order passed. I filed a contempt application,
Okay.
but Lordship, nothing has been released.
Let me come back after the recess. Sure.
Well, kindly, certainly not. Kindly tomorrow, my lord. Enough of your matter.
A second, Lordship, this is a very urgent. Since 2024 January, I am
Just
not
first
getting the
find
pension.
out. Let him place his case. We'll see.
Second.
My lord,
नहीं करना पड़ेगा
my lord, may I be
I
permitted
for
to
the details.
mention, my lord?
My lord, under extremely urgent circumstances, my lord, I have been taken into custody, my lord. My lord, only gives me 1 minute, my lord. Consumer Court had issued warrant on the earlier date, my lord. Seized this order, my lord. I was represented through my learned advocate, my lord. I have placed my medical documents, my lord. Today I prayed for bail, my lord, and I have been taken into judicial custody, my lord. Kindly appreciates I have been backed by this honorable court's judgments, my lord, where, my lord, it has been stated that the Consumer Court in an
What is
execution
the
proceeding. Yes, my lord.
case in which determination this case is?
My lord, this CRR, my lord.
Okay.
CRR, your lordship has it, my lord.
Which court?
Yes, my lord.
Which court?
My lord, State Consumer District Court 29, Honorable Justice Ajay Kumar Mukherjee, my lord.
Rajikul Mukherjee, I am not interested.
Huh?
I am not interested.
এই কোর্টে না তো কার কাছে আছে আমাকে বললে এই কোর্টে আছে
You have the copy of the order?
Yes, my lord.
Order of the Honorable Chief Justice?
My lord, as Honorable Justice Ajay Kumar Mukherjee is not sitting, my lord, his determination has gone to Honorable Justice Dinesh Kumar Sharma. Now, my lord, Honorable Justice Dinesh Kumar Sharma is also not sitting, my lord. Therefore, my lord, that is why, my lord, otherwise, my lord, I would not have your lordship, my lord. I know your lordship.
This sort of orders I have not received.
But my lord, Dinesh, Honorable Justice Dinesh Kumar Sharma was taking up the determination of Justice Ajay Kumar Mukherjee, my lord. Now, as he is not sitting, my lord, I have no other option left but to come and approach before your lordship, my lord.
But I am with the determination of Justice Dinesh Kumar Sharma. There is no mention in the order of the Chief Justice that also the determination of Judge Ajay Kumar Mukherjee.
My lord, subject to correction, my lord, that also includes the determination of Justice Ajay Kumar Mukherjee, my lord.
Ask him, they cannot determination. Sure, yes.
Your Lordship, as I have stated, the Lordship, that A category scale in respect of the candidates who have completed the sessions in 2005 and 6, Lordship, already has been upheld by up to the Honorable Division Bench. Now, Lordship, petitioner filed initially a writ petition for granting A category scale from the date of along with the retirement benefits and pensionary benefits from the date of completion of his examination. Now, Lordship, this writ petition was moved before this Honorable High Court and Lordship passed an interim order. Lordship, kindly come. That is page 31 of my writ petition. Lordship, I am just reading the entire judgment order. It will appear. The petitioner was an assistant teacher at Purapara Primary School, a school under Rampur at South Circle, Birbhum District Primary School Council. On attaining the age of superannuation, he was retired from his service on January 31st, 2024. The disbursement of retirement benefit petitioner is being delayed as a dispute has been cropped regarding entitlement of get A category scale of pay. On the said issue, the chairman of the said council, the respondent number 4, herein by the order dated December 13, 2024, was directed to file a report on such report being memo number 9, January 7, 2025, with enclosure thereto is filed and let it be kept with the record. The petitioner took the high secondary examination for the second time and secured 50% marks in the said examination. The respondent number 4 treating the said score as the benchmark to get the said scale of pay. In his report has fixed the said entitlement petitioner with effect from the date of publication of his result, that is July 1st, 2015. Mr. Such and such learned advocate petitioner submits that the petitioner since has attaining qualification of PTT primary teachers training by virtue of the judgment of the Honorable Division Bench, that is dated January 5th, 2024, passed in mat number such and such, is entitled to A category scale of pay. As such, the respondent number 4
should not have given effect to the entitlement petitioner to get a such scale of pay from the date of publication of the result of the higher secondary school examination. He further submits that the said entitlement of the petitioner should have been from 15 June 2006, that is the date of completion of the said PTT's course. Mr. Such and Such learned advocate for the council submits that no doubt the petitioner in terms of the above mentioned judgment of the Honorable Division Bench is entitled to get scale of pay on the basis of the training qualification PTT. But unfortunately, the said judgment has escaped the notice of the respondent number 4. Consequently, in the said report, it has been opined that the entitlement has been accrued to the petition on publication of the result in the said higher secondary examination. He, however,
just a minute. কে মুভ করছিল নামটা কি? হ্যাঁ, একটু অ্যাসেটেন্ড করে নাও তো কে আছে ওটা মুভ করছিল, যেটা যদি আসেন ওনাকে বলবেন মুভ করার জন্য, ঠিক আছে? Yes.
He, however, objects to the prayer of the petitioner that the said entitlement should be given effect from the date of completion of the training qualification, that is July 14, 2011, particularly when an appeal since is pending on the said issue. However, heard the counsel for the parties and on perusal of the records, the court is of the opinion that the entitlement of the petitioner to get a category scale of pay in terms of the aforesaid judgment of the Honorable Division Bench matures on the acquisition of the primary teachers training on training qualification. The said entitlement should be given effect from the date of publication of the result of the said course, that is July 14, 2011. Whether the said entitlement would be from the date of completion of the course would be decided on the disposal of the appeal in which the issue is under consideration. In the meantime, the respondent number 4 directed to take steps for preparation of the pension papers of the petitioner expeditiously, and after awarding a category scale of pay to him with effect from July 14, 2011, and also disburse the arrear salaries if there is any to the petitioner, as paid for the petition considered upon exchange of affidavit. Now, Lordship, after this order, we have communicated this order to the concerned district inspector of schools. Lordship, nothing disbursed. Now, Lordship, kindly come my, Lordship, the service book, which was prepared by the concerned authority, that is page 66.
Yes.
Page 66, that's the bottom. The teacher will retire from his service on 31st January 2024. On the date of retirement, superannuation, the basic pay such and such, such and such. Now, Lordship, kindly, in this writ petition, Lordship, kindly come to the my prayer. Lordship, in this writ petition, what I am praying, Lordship, so far the A category scale is concerned, whether it will be it will be disbursed from 2006 or with the effect from 2011. Lordship, this issue is not before your Lordship. I am not praying any A category scale before your Lordship, because the issue of disbursement of the A category scale, whether I am entitled or not entitled, it is sub judice in the another writ petition. In the said writ petition, the interim order has been passed, that which I have placed. Today I am praying, Lordship, the petitioner since 2024 January, I am not getting any pension and gratuity, nothing has been disbursed. My son is a student of medical college, Lordship, I am unable to continue his studies. So, Lordship, whatever according to the respondent number 4 of the state respondent, whatever the pension amount, whatever the gratuity, kindly direct them to release within a certain time. Today, this writ petition, Lordship, this is for the same purpose. I am not praying in A category scale. I am not going to any dispute regarding A category scale, whether I am entitled or not. That will be dealt with the separated petition, which is pending. Now, Lordship, today I am praying, whatever my entitled, according to them, not my, according to them, whatever my entitled, whatever I am entitled, the pension, 10,000, 20,000, 1,000, whatever the pension amount, and whatever my gratuity and arrear pension, Lordship kindly direct them to release their same within a period of 2 weeks.
Yes.
Like my instruction is, since the entitlement of a category scale of pay, petitioner asked for A1 A category scale of pay, that is under sub judice matter, appeal is pending. That's why the petitioner's pension file returned back. And in the prayer portion, kindly see prayer portion, he asked for all admissible dues. He never asked for that. We have not claimed for a category scale of pay. He never asked for. That's why his pension file returned back. And appeal he obtained PTT degree qualification in 2000.
What has been noted in the service book while returning the pension files?
And so far, in respect of my, there is no appeal pending in respect of my issue.
Petitioner asked for a category scale of pay. Kindly see page 2, my instruction. Last paragraph. Whether the said entitlement would be from the date of completion of said course would be decided after disposal of the appeal, in which the said issue is under consideration. That's why petitioner's pension file is returned by DPPG. If his claim is waived off, the category scale of pay, then we are ready to pay the pension and all area dues.
When was the results declared?
2011?
14 July.
Yes.
The cut-off date is 2006, Millard. If persons who was
And there is an interim order to
PTT
disburse the pension
qualification
since
in
2011.
2006, they entitled to get a category scale of pay. When the petitioner is in service, he get a category scale of pay, Millard. And now he is asked for all admissible dues.
But then the A category scale has been given effect to from 14 July 2011.
My lord. He acquired qualification in 2011.
Now the only issue is whether he will receive that from the completion of the course or from the date of declaration of the result. If he is entitled, because since the appeal is pending, the court has kept it pending, whether it will be from completion. So far as his entitlement from the date of results are concerned, that date has been mentioned as 14 July 2011. So why this has been withheld? What is the reason? In the subsequent paragraph, where the court has in page 3 of the order, it says that whether the said entitlement would be from the date of completion of the course would be decided after disposal of the appeal. Then it says, in the meantime, response number 4 is directed to take steps for preparation of pension papers, taking the A category scale from 14 July 2011. This is direction. No appeal has been preferred against this order.
Petitioner acquired qualification not in 2006. That is under challenge. He acquired his qualification in 2013.
11.
And cut-off date is 2006, my lord. That is the main problem.
No, no. You will quote a order of a particular part of the order which favors you. But there is a direction on response number 4 to take steps for preparation of pension papers, giving the effect of A category from 14 July 2011.
My lord.
So why that has not been complied?
My lord, but one appeal is pending.
But this order, there is no appeal.
Appeal is pending. Appeal is pending when this order was passed in WPA 22059 or 2024. At that point of time, the appeal was pending. The court has directed respond number 4 to prepare the pension papers taking the A category scale from 14 July. Is any other order passed in the appeal which obstructs the authority from granting the pension?
We have no instruction. I will take in instruction, my lord.
Lordship, there was a direction of this honorable court to take instruction in only this issue for disbursement of pension and gratuity. So, Lordship, even Lordship, if we see the state disputes that I am entitled to get a category scale or not, Lordship, direct them to release whatever they calculated the pensionary amount to release in my favor.
If your lordship direct, then I will inform the DI.
This writ petition is still pending, WPA.
Yes, that is right. No affidavits filed, but this way.
Affidavit of service filed on, no. This is report filed by the state is taken on record. By the present writ petition, the petitioner seeks for disbursal, seeks direction upon respondent numbers 3, 4, 5, and 6. To disburse the monthly pensionary benefits and other retiral benefits, as well as admitted dues, according to the respondents to the petitioner within a period of 1 week from the date. The petitioner states that contents that he was in which school he was appointed. He was appointed in which school?
So initially, I was appointed Horirampur Primary School within Rampurat North Circle.
Was appointed as a primary teacher. Primary teacher in Horirampur Primary School, Rampur Hat North Circle. No. Petitioner was appointed as an assistant primary teacher under exempted category in the year 2002 at Horirampur Primary School within Rampurhat North Circle, আগেরটা কেটে দিন, as an untrained teacher on 27th March 2002. Upon permission from Chairman Birbhum District Primary School Council dated 26 July 2005, the petitioner joined at Shampahari Government PTT Institute for completion of primary teachers training for the sessions 2005-2006. The petitioner successfully completed the training on regular basis. However, due to several court cases, the primary teachers training examination 2006, trainee examination 2006 could not be held in the year 2006. Stop. Ultimately, the examination was held in the month of February 2011 and the results were published in the month of July 2011. The petitioner retired when? Paragraph.
31st January 2024.
The petitioner on superannuation retired on 31st January 2024. However, since retirement, he is not getting any pension.
No.
However, since his retirement, the petitioner is not
Pension and gratuity.
received any pension and gratuity. Hence this writ petition. Mr. Prosenjit Mukherjee, ওপরে দিয়ে দিন তো রিপোর্ট, বললাম না রিপোর্ট ফাইল বাই দিস Mukherjee, learned advocate for the petitioner, submits that the pensionary benefits of the petitioner has been withheld on the ground that whether the entitlement of the petitioner of A category scale of pay would be from the date of completion of the said course, that is primary teachers training course, or would be from the date of declaration of the results is pending before the appeal. The petitioner in the present writ petition has not claimed his pension on the basis of A category scale of pay. The petitioner seeks a direction upon which is the disbursing authority?
Lordship, the respondent number 4, District Inspector School, Birbhum at Siuri.
Respondent number 4 seeks direction upon respondent number 4 to who is it? PSC will forward the same to the Commissioner of School Education. Treasury will disperse the same. Which respondent? Which respondent?
Yes, Treasury is the part.
Huh?
Respondent number 7, my
Eight.
lord.
No, 8.
And we have already forwarded the same to the
7 and 8, my lord. Director of Pension
they are the
Provident.
report of the state. You are for whom? I'm for the PSC. You come to this side.
Respondent number 7 and 8 is the disbursing authority.
7 and 8.
My lord. DPPG and Treasury Officer.
7 will be the disbursing authority. Treasury officer will carry out the direction of
disbursing authority.
7.
Director of pension 7.
6 direction about respond number 7 to disburse and release the pensionary benefits as the petitioner entitled on the date of his superannuation. The petitioner is not claiming a category pay scale at this stage, since the matter is pending before the appellate court. Learned advocate for the state as well as the state submits that the issue whether the petitioner will be entitled to a category of pay scale is pending before the appellate court. From the date of completion of his course or from date of declaration of the result. Therefore, the pension disbursing authority is unable to disburse the pension. It is not in dispute that the petitioner has completed the training qualification, that is PTT. The question whether the petitioner would be entitled to a category scale of pay from the date of completion of the course is pending before the pending in appeal. What is the number of the appeal?
So far, kindly record my submission. There is no, so far my instruction, there is no appeal is pending regarding this issue.
Appeal order is at page 99, Lordship.
That is the disposal order.
So why did you submit that it has not been disposed of as yet?
No, Lordships, this is the recorded statement has been recorded of the state that the appeal is pending.
No, the court in the interim order also court records that the particular.
Yes, that is the submission of the respondent.
No.
AP.
In Justice Basu's order, it has been recorded whether the said entitlement page 3,
Yes.
page 33 of the writ petition would be decided after disposal of the appeal in which the said issue is under consideration.
Yes, so this is the kindly come, heard the learned counsel for the parties, and on perusal of the records, the court is opinion that entitlement of the petitioner a category scale of pay in terms of the aforesaid judgment of the Honorable Division Bench matures on his acquisition of primary teachers training. As training qualification, the entitlement should be given effective from the publication of the result. Now, Lordship, this pendency of the appeal is submission of the state.
By instruction.
So far, my instruction is concerned, Lordship, the appeal which was regarding a category scale already disposed of, I have annexed the order.
In page 3, having page 2 starts with having heard the learned counsel. Now the court has said in page 3 of that order, page 33 of the writ petition,
Yes.
would be decided after disposal of the appeal in January 2025 court records.
Lordship, kindly come paragraph 2. This is the submission of the state advocate, learned advocate, Lordship. The Honorable Division is entitled to the said scale. This judgment had escaped from the notice of Respondent 4. So consequently, in the said report, it has been opined that entitlement of the had accrued to the petition on publication of the result in the higher secondary. He, however, object the prayer should be given effective from the completion of July 2014. Now, particularly when an appeal since is pending the said issue. So this is a submission of the state advocate that appeal is pending. But so far my instruction, there is no such appeal is pending.
And my instruction is kindly
Stories of the
see
opinion that
page A5.
internal phase will change.
My instruction, my lord.
The said internal would be given. Court has recorded in page 3 that this particular question is pending, whether he will get it from the completion of the course or not.
So the information of the appeal is pending that comes out from the submission of the learned advocate for the state advocate. Kindly come page 32, second para, last portion. When an appeal since is pending on the said issue.
Then if the appeal has been disposed of, what is the order passed in the appeal?
So for the kindly come this order. So for the appeal, which is Lordship, entitlement has been accrued for entitlement A category scale, that order I have annexed. Kindly come page number 99.
Yes. Now, what is the order passed?
The Lordship, kindly come paragraph number
Para 10, Lordship. Page 104. 104.
Yes, Lordship, kindly come paragraph 7. The state of President considered that since the petitioners were appointed before the cutoff date, obtained 1-year PTTI training in the sessions 5 and 6 would be entitled to get A category scale of pay in terms of the relevant notification as duly communicated by the Commissioner of School Education in the letter dated such and such. So lots of issue has been held by the Honorable Division Bench. They are entitled to get A category scale.
That is under challenge. The order passed on
Okay, this is a disposal appeal.
5th January 2024. And our instruction is 11th July 2025, my lord.
14 July.
My lord.
That was
Our
a separate
instruction-
appeal, maybe separate.
Annexure A5, my lord, kindly see our instruction.
In which paragraph of this appeals court order it is held that upon completion of the course, date of completion of the course, they will be entitled to A category.
This is the issue. Lots of in this appeal, the Honorable Appeal Court only held that the candidates who have completed the training for the sessions 5 and 6, 1 year, they are entitled to A category scale. But when it will be entitled to from the completion of training or from the the date of publication of the result. This issue, the Honorable Division Bench has not, this issue has not been decided. This issue decided by the Honorable Single Judge, kindly come to, the Honorable Single Judge has decided this issue. Kindly come page 107.
Same DPSC appeared in this matter. Kindly come. Paragraph 18, page 111. This is the Honorable Single Judge's order. By the reason of this argument, the right of the petitioners under circular number 4th March 2013, Supra, would revive automatically. In effect, the petitioners would be entitled to get a category scale of pay upon expiry of 1 year code 5 and 6, when the final examination were to be conducted in June 2006.
In this writ petition,
Now,
the
Lordship,
petitioner
this writ
not
petition
claim for
was
a
moved by
category.
me. I, as a learned advocate, moved this writ petition. Against this order, no appeal has been preferred. Lordship, kindly record
No,
my
the issue has gone to the division
But
bench, Lordship.
I don't know whether
That
other
issue is
other
gone.
petition.
That issue has been.
What is the appeal number?
Yes, that is the
Well, at this stage, petitioner has not claimed for a category scale of pay.
No, that is pending. His issue is pending in different repetition.
Now, my
A category is pending in different
His prayer
repetition.
is
His
not,
repetition.
Claim
He cannot claim A category
scale of
in
pay.
this repetition only. It is pending before the Honorable Single Bench. Same prayer cannot be made over here. A category তোমার pending আছে দাদা
Question is
petition টা এখনো pending আছে
that
ওটাও তো এখন
in
এখানে তোলা
effect,
যাবে
I will supply the number on the next day. At this stage, he asked for only disbursement of a except
that can be
a
disbursed
category.
Lordship, from
That can be disbursed.
2000 on the date of publication that can be disbursed. And the council has also given consent to the state.
You have got the number of the appeal which is pending.
Lordship.
The memo number is given, but appeal number is not given. Kindly see annexure A5, our
Mukherjee?
instruction.
Appeal number?
Lordship, so far my instruction, this issue, so far 5 and 6 candidate, no appeal is made. This is their submission, Lordship. On the basis of their submission, the direction for affidavit has been passed in the earlier petition.
Now petitioner asked for disbursement of his retirement benefit, accepting the A1 category scale of pay. He has not asked for A1 category scale of pay.
He may not ask for, but if you calculate his pension benefits, then at that point of time, if somebody is granted A category scale of pay from 2006, why should he be deprived?
Because Lordship, that issue is pending in another repetition by my learned friend, by the same repetitioner. Then that petition have to be tagged with this petition, and that it will be heard analogously.
Analogously.
Because that issue he has already challenged A category. And again now he can
says that there is no appeal pending.
No, yes, Lordship, that order Justice Basu, Lordship, but he has relied on. It is annexed over here. That petition is still pending today.
Pending and
Interim order, there is no appeal is pending.
No, in interim order there is no appeal.
Petition is
In
pending.
that respect, Lordship, from 2011 that can be disbursed, but not beyond that.
তাহলে ওনার সাবমিশনে যেখানে বলেছে না যে অ্যাপিল পেন্ডিং ওটা কেটে দিন। Learned advocate for the state informs that the date of entitlement whether whether the teacher who has completed the PTT training in 2006 would be entitled to get such A category scale of pay from the date of completion of the course or from the date of declaration of results is pending before the declaration of result is pending before in appeal. Upon considering the submissions of the respective parties, respondent number 7 is directed to disburse the pensionary benefits to the petitioner with regard to his entitlement as on date in accordance with law. Within a period of 4 weeks from date of communication of the order. With the aforesaid direction, the writ petition being WPA 14442 of 2021 stands disposal. Good. পেয়েছো ওনাকে ওনাকে পাওয়া গেছে ডিটারমিনেশনে বলা ছিল ওটা
I am for the replace grievance.
কিন্তু ওনাকেই অর্ডারটা করা ছিল from 3rd November to 7th November.
My lord, I am appearing on behalf of estate, my lord.
তপনদা
অজয় মুখার্জির ডিটারমিনেশন
না
স্টেটের খালি ওদের দেখিয়ে নিয়ে হ্যাঁ
ও আচ্ছা আচ্ছা
আসেনি
Kindly come to my list of dates. But the petitioner was appointed to the post of assistant teacher on 5th December 1991. Now, also petitioner subsequently transferred. Now, petitioner, the district, this is the 26th July 2005. The chairman, Birbhum District Primary School Council, directed the petitioner to complete the training. The petitioner was released from the training institute on 17 June 2006. That petitioner has completed the course. Now, petitioner duly joined after completion of the training, that is 19 June 2006. The result was published 14 July 2011. That is the petitioner has 5 and 6 category. Result published, PTTI result published on 14 July 2011. Petitioner was granted a category scale January 2020. Lordship, here a category scale has been granted from January 2020. Petitioner returned from the service on 22. The pension payment order. Now here I have prayed for. Lordship, the A category scale from the date of completion of my training, that is since Lordship June 2006. Now Lordship, kindly come. The notification that is paid 48.
Yes.
Page 48, grant of a category scale of pay to the primary school teacher. Now, Lordship, kindly come. I did reference to the right memo number such and such, and without prejudice to the earlier orders of the Department of the Regard, I am directed to say that in terms of the order of the National Council for Teacher Education by such and such, and subsequent clarification dated such and such, the following categories of primary school teachers shall be treated as trained teachers as they may be allowed a category scale of pay. Now, Lordship, 1, 2, kindly skip, kindly 3. Who have attained 1 year, Lordship, kindly got it, Roman 3. Who have attained 1 year of the diploma in education from the state government and appointed as a teacher on or before 31st December 2005 shall be treated as a trained teacher. So also I am entitled to be a trained teacher and get a category scale in terms of this previous notification as well as which is standing at present existing, that is 4 March 2030. Now also kindly come page 50.
Yes.
So page 50 is the order of the Honorable Single Judge that directed the item 51. I direct district inspector school. It's a different context, it's a different category. To grant petitioner enhanced salary due to attainment of such state qualification from 31st July 2019. By the decision of the authority granting benefits qualification from the date of publication of the result. Tell us if the conflict finding out the date, just therefore the petitioner is entitled to get benefit from the date of completion of the DLA course, that is from 31st July 2019. So let's say a decision has come that from the date of completion of the training, let's say the candidate, the assistant teacher is entitled to get a category scale, not from the date of publication of the data. Now let's say kindly come. This is the division bench order. So this division bench order is appears from page 53 that the candidates who have completed 1 year training entitled to get a category scale. That is page 53. So this is already, I have cited it, another repetition. That is also kindly come. Page 56, also entitled to get a category scale. Now page 59, this order also relates to that the candidate who have completed ITS 5-6 training is entitled to get a category.
No, this entitlement of A category scale is not disputed. This has been given to you.
Up to page 66, it is matters relating to this type of teachers, assistant teachers who have completed the training 5 and 6, result of 2011 entitled to get a category. Lordship, the issue has been, Lordship, is no more racing to. Kindly on page 67, Lordship, kindly allow me to read the entire order because the issue has been decided by this court that since when I am entitled to get a category scale. Now, what is the reasoning behind it, which has been held by this honorable court? Kindly allow me to go through the entire order. Kindly come page 67.
Yes.
I am reading from Lordship paragraph 2. The issue decided here is on which day are the petitioner entitled to get a category scale of pay. All the petitioners are working teachers who entered the service of the DPS Birbhum without a valid PTT qualification. They undertook the course of obtaining the qualification but actively each of the petitioners underwent a 1 year course sanction of the DPSC at the institution, recognize the principle of primary education. The DPSC as adverse several arguments in support of the contention that petitioners should be entitled to academic stay after the next date of last examination of the teacher's training course undergone by the petition. Demands by the council for the DPSC on a decision of a division score, for another, reported in such and such, proceeding was a public interest litigation. The issue in the case that since the NCT decided to recognize for a 2-year course, and the institutes concerned where the petition under the course were not recognized by the NCT, whether the courses undergone in Australia by the petitioner was valid or not. In the PIA, it was ultimately held that since the institutes are not recognized by the NCT, the course are by the petitioners not be accepted. The institute that directed to refund the fees paid by the petitioner. It also followed as corollary that the course be only for 1 year, where the otherwise not recognized by the NCT. The petitioners appear to be caught between the David and the deep sea. They had undergone 1-year course on the basis of recognition and recognition of such institutes offering such course by WP, BPE, and with the permission of the DPSC, such 1-year course and as from the High Court and NCT. The petitioners wasted 1 year of their career and life. The board state DPSC have realized the error in misleading the teachers approach in the NCT for a solution. The solution act was that as one-time measures in the petition undergo bridge course for 1 year, the addition of 1 year course already undergone by the teachers, they be deemed to be a law qualified. It is the only therefore that the examination course held in 5-6 was held in the year 2011. It is from the day after the last day of the state examination according to the DPSC that petitioners are entitled to take a stay. Therefore, even the DPSC has not taken 1 year bridge course as a condition precedent for a category scale of the petition. The letter for the petition referred to the subject report was 2013 issued by the Joint Secretary School Education Department Elementary Education branch, from where there could be an interpretation that the actual qualification and the consequence were referring to 1 year course as recognized by the board. The teachers, they have also 1 year course. They however played a scale of the day of completion of the original 1 year PTT course, that is 2006. At the instance of the DPSC and WP, such and such Joint Council, DPSC, referring to the page state of Procedural and other, which was heard in several other petitions dated 7th February 2014. Circular of Education Department's which budget branch of the government of West Bengal 17th September 2024 was held hearing and the benefits of high scale of qualification. Only from the last the law followed across the country as such. In the same principle, however, may not apply in the particular facts and some case of the repetitioner believe being relied upon the board and BPSC and undertook 1 year course and legitimately expected to get the academic scale of pay after 1 year in June 2006. The board and BPSC have therefore stopped from going back on their representation that the petition under the valid training course, the petitioners must be understood to have altered their position and have acted upon the same. The said position of Procedural State Supreme must be have been eclipsed since affecting the board as a special case. Not only seek the final examination conducted by the state and recognized institute, but also subsequently undergo a 1 year beach course. By the reason this argument, the right of the commissioner under circular number will be revived automatically and effect the petitioners would be entitled to a category scale of pay upon expiry 1 year course, financing when the final examination is conducted. DPSC has itself argued that after successful completion of the examination of 1 year eligible held after 5 years. Therefore not to be counted. If completed successfully, petitioners therefore cannot be penalized for delay of 5 years holding the examination of 5 and 6. The legitimate expectation of the part of the petitioners of a category scale of accruing in June 2006 crystallized and matured into promissory estoppel with the subsequent steps taken by the board. Undergoing examination 2011 of a 4 completed in June 2006. 1 year each course constitutes an ex post regularization of what can be best categorized as an irregularity of 1 year course undertaken by the petitioner for not fault of the part of their part. Such irregularity must be occurring solely at the instance of the court. The issue as it does not appear to have been raised. It was by any DPSC state some orders recognized by the entire state from 2006 are ordered related sufficient. So these are the order already has been passed for granting a category scale. That is what I have stated different WPA number that of the June 2006. Now also kindly come page 75. But since June 875, page 75 to page 78, all the orders passed by this Honorable High Court directing the state respondent grant a category scale from June 2006. And these orders, neither of these orders, nor the order passed, that is page 67, no apparent. Now today I am also praying for grant of a category scale with interest. But because already from 2020 I am getting a category scale from 2006 to 20. The category scale which has been area to be disbursed in favor of the petitioner along the
So I am opposing his prayer lordship. I have a specific instruction that after the course in 2005-6, petitioner has again done another course in respect of the education in 2017-2019, which the petitioner has not disclosed in the repetition. Second of all, the orders my learned friends of the single bench are relying on, I have many contradictory orders and this single bench order is not binding upon your lordships. Third of all, my learned friend has shown one order of Justice Gangopadhyay, where it has been categorically mentioned that on the date of completion of the course, a category should be given. So, in case of 2005-6, the examination was held in 2011. The exam was not held. Maybe the course was complete, but that petitioner have to pass the exam. that examination was, so these two are different categories. So that is not binding on this or on this
continue
repetition,
tomorrow.
Lordship. Lordship, may it be kept after
the-
a week, Lordship, because I have to gather that another course what my learned friend has not disclosed in the repetition. May I get a week's time, Lordship? Though I can file a report, Lordship. May time be given, Lordship.
By the present writ petition, affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner challenges the date of entitlement to A category scale of pay given to the petitioner from 2019, which ought to have been given from June 2006. State seeks to file a report.
Not the state, Lordship, the DPSC Birbhum, District Primary School Council,
DPSC
Birbhum.
Birbhum. Respond number?
Respond number, Lordship, 4 and 5 also.
4 and 5 seeks to file report. Let such report in the form of affidavit be filed by
3 and 4, Lordship.
3 and 4 DPSC.
Not 3, Lordship, 4.
4
Only 4, Lordship.
within a period of 1 week. Exception to such report, if any, be filed within a week thereafter. List this matter after 2 weeks under the heading. Wait again. Hearing any.
1 week report, Lordship.
After 2 weeks, he will get 1 week for, if he intends to file any exception to the report, he will file. After 2 weeks, this will come up under the heading hearing.
Grateful, Lordship.
Yeah.
Deeply obliged, my lord.
Please.
My lord, I apologize, my lord. I required
Oh, no, after you have left the court, you would have shown the determination, no? From 3rd to 7th. What is your problem?
Lord, what has happened in the state forum, Lord, warrant was issued against my client. Now on that day, on the date of issuing.
Tomorrow. Tomorrow, let's go.
My lord, Justice Joyshan Gupta has the determination of Honorable Justice Ajay Kumar Mukherjee, my lord. So, my lord, he has granted me leave. Now tomorrow the matter would appear before him, my lord. I'm extremely sorry.
I asked my court officer to find you out.
Just ran
Because the determination from 3rd to 7th is showing of Ajay Mukherjee with Justice Dinesh Sharma.
exactly, my lord. That was
There is an order passed now. Justice Sengupta has been given the determination.
he confirmed that no, it
Okay.
some miscommunication.
Then the matter has been resolved. Thank you. Okay.